You're unmuted.
Welcome, everybody. I'm going to call to order the special town council meeting today, Monday, August 19th, 2024. It is 10:01 a.m. We are combination of in-person at Rebecca Hall at 113 West Columbia Avenue, Telluride, Colorado, and hybrid online. First item to take care of is a call to order, and starting on my right in my call to order.
Helen 11.
Jesse Rearguez,
Geneva Shawnette. Nancy.
Ashley Von Sprecken,
Dan Enright.
And Teddy Erico as mayor. Item 1, public hearing. 1A, consideration of an appeal of an approval by the Planning and Zoning Commission on June 27th, 2024 of an application for a minor subdivision to remove designated 15-foot rear setback on the plat and optional rear access within the 15-foot rear setback pursuant to Land Use Code, Section 6-402C, legal description, lots 5R, 7, 8, and 9, Block 20, East Telluride addition to the town of Telluride, address 835, 845, and 855 East Columbia Avenue, and Lot 5R, Block 20, ETA, addressed to be determined, Zone District Residential, owner Frank C. Winter, Jennifer R. Winter, San Miguel Properties, LLC. The applicant is Maura Trumbull from CCY Architects. There is a notice of appeal from 7/11/24, appeal hearing notices, an introductory staff memo, appeal brief to town council that was posted 8/12/24, and record of the Planning and Zoning Commission meeting on June 27th, 2024. To introduce into the record documents in this public hearing, which consist of the following: the Town of Telluride Home Rule Charter adopted on October 27th, 1977, as currently amended. The Town of Telluride Municipal Code adopted on July 15th, 1997, as currently amended. The Telluride Land Use Code adopted on March 15th, 1988, as currently amended. The Town of Telluride Master Plan as adopted on August 29th, 2026. The appeal record and town council packet materials prepared by the Town of Telluride Town Clerk. And Tiffany, there were no other documents received after that, right?
No.
Okay, just to clarify. And then with that, we are going on to item number 2 of the public hearing, which is a staff presentation. And online, we have Ron Quarles, and I will hand it off to Ron.
One sec, quickly. Just for purposes of conflict check, my husband did previously represent the Winters before handing this case over to Garfield and Hecht. Kevin has previously advised that there is no conflict, but I do want to bring that up so that all of council is aware. And if you have an objection, please let me know.
Is there any objection from council?
No.
Seeing none, thank you for that, Mian. Seeing no objection for Mian's contribution to this hearing, we will then go back to Ron Quarles, staff with the Town of Telluride.
Thank you, Mayor Erico. Town council members, Ron Quarles, Town of Telluride interim senior planner. This is an appeal of the decision of the Planning and Zoning Commission to approve the minor subdivision at the regular meeting of June 27, 2024 for lots 5R through 9, Block 20 East Telluride addition. My presentation will be a description of the affected lots, a summary of the application and changes requested, the recommendation of staff, and the decision of the Planning and Zoning Commission, and a rereading of the resolution of approval approved by the P&Z at the meeting. So the property is located on the north side of East Columbia Avenue, just west of Columbine Street and south of East Pandora and Primrose Lane as it extends northward up the hillside. The property is zoned residential. So in 1997, the lots were originally platted as lots 5, 6, or prior to 1997. The lots were originally platted as lots 5, 6, 7, 8, 9, 10 of Block 20 of the East Telluride Addition. They were replatted in 1997 as lots 5, 6, 7, and 9 of Block 20 of the East Telluride Addition. The replat combined a portion of Lot 9 with 10, shifted some of the lot lines to the east, and represented the vacation of a portion of Columbine Street that was incorporated into the larger Lot 9. I provided some history in the memo for the June 27 meeting that's in your packet. Staff provided some of the background of how this occurred. The town, who owned the lots at the time, requested these changes while it was negotiating the transfer of the lots to private landowners. Back several years, even before 1997, earlier in 1979, the town council authorized a land swap between the town and the owners of land that is now the town park. The land swap between the private owners and the town occurred on the same day that this replat was recorded. At the time of the subdivision approval, Planning and Zoning Commission expressed the need that there be an option for future access from the rear of the lots, rather than from the street frontages, primarily Columbia Avenue. At a meeting in October of 1997, P&Z granted an initial approval of the replat with a condition that included the creation of Lot 9 as a larger lot of 5,000 square feet and the establishment of a 15-foot rear yard setback containing a driveway easement. The replat was then reheard in December of that year because of concerns that the rear access easement would be forced upon all of the property owners if just a single property owner made the decision to access from the rear. The initial approval then was modified in December of 1997 by removing the requirement for a rear access easement unless all property owners agreed to the establishment of that easement. So when the plat was recorded back in 1997, an agreement was recorded with the plat or simultaneous with the plat, establishing future access from the rear of the properties within the 15-foot rear yard, and it was subject to the unanimous consent of the property owners or by means of access from street frontages. In 2015, lots 5 and 6 were combined as a single lot, Lot 5R, and the agreement that was in place and the 15-foot rear yard continued to be or was identified on the replat of lots 5 and 6. The specific language in the agreement that was recorded provided for access from the rear of the property within the 15-foot rear yard setback if unanimously agreed to by all landowners within the subdivision and memorialized in a written agreement. Or in the alternate, solely by means of 3 access points located on East Columbia Avenue, or access to Lot 9, access to Lot 9 exclusively from Columbine Street. So the application that was submitted for consideration by the Planning and Zoning Commission is requested to make one change to the plat by adding the following note. And I'll read the note as it was identified on the plat and submitted to the Planning and Zoning Commission. 15-foot rear yard setback as depicted on Plat Book 1 at page 2314 and on Plat Book 1 at page 4714, and access agreement per reception number 316103, vacated per reception number to be determined. If the access area of the rear yard setback is removed from the plat as approved by the Planning and Zoning Commission, the minimum rear yard established by the land use code would continue to apply to these lots. And that, as we pointed out at the meeting on June 27, the minimum rear yard for lots in the residential zoning for principal buildings is 15 feet or the average setback of the block in which the parcel lies, unless modified by HARC. However, the setback shall not be less than 5 feet. Accessory buildings of 5 feet. Staff supported the application at the meeting based on the owner's decision to remove the rear access with the rear setback and to remove any confusion in future development that is subject to these requirements of future buildings in the established land use code. Public hearing was held on June 27, 2024. Testimony was received by the applicants, Maura Trumbull of CCY Architects and Mary Elizabeth Geiger of Garfield Hecht. Public testimony was received by Lexi Tuddenham, Carl Kravitz, and Gabby McDonald. The Planning and Zoning Commission approved a resolution as a part of the public hearing process. And as I stated, I will reread this for the record. The approval was based on the following language: whereas the owners of lots 5R, 7, and 9, Block 20, East Telluride Addition, request a minor subdivision application to remove a designated 15-foot rear vehicular setback from the subdivision, and the Planning and Zoning Commission considered the application at a public hearing held on June 27, 2024, with a notice of such hearing provided as required by the Telluride Land Use Code. And whereas the Planning and Zoning Commission finds that the application meets the following findings: the application meets the applicable requirements, purpose, and intent of the Telluride Land Use Code. The application is consistent with the subdivision regulations and subdivision design criteria contained in section 6-408 of the Land Use Code. The application is consistent with the streetscape design standards and construction specifications. And finally, number 4, the application is consistent with the Telluride Master Plan. Now therefore be it resolved, Planning and Zoning Commission of the Town of Telluride, Colorado approves the minor subdivision application to remove a designated 15-foot rear vehicular setback with the following condition: the agreement to nullify rear access among the property owners shall be recorded at the time of the recording of the minor subdivision. The agreement shall also preserve the maximum of 3 points of access from Columbia Avenue and 1 point of access for Columbine Street as outlined in the original agreement. The motion was made, vote of 4-1. The approval was given from the motion that was made at the meeting. And Angela Dye, Todd Brown, Kathy Green, Peter Sante voted in support of the minor subdivision. Charles Dalton voted no. And with that, that concludes my presentation. Be glad to try to answer any of your questions.
Great, Ron. Thank you very much. Are there any council members that have any questions for Ron in his staff presentation? Great, Ron, thank you. We will move on to item number 3, and that is the appellant's presentation. And we have Lance Ingalls here to present.
Thank you, Mr. Mayor. Can I ask a question before we begin? I was told on Friday I would get 30 minutes for this presentation, but that's fairly late in the process. So I've done my best to pare my comments down to that. Will I be given any leeway, or is that a rigid 30 minutes? I've asked the clerk to tell me when there's 3 minutes left, but I might have to skip part of my presentation if I'm not done. So I just need to understand.
Yeah, I mean, if you do the best you can, I don't mind giving you a couple extra minutes. We would just afford that same courtesy to the other attorney if they need more. You know, I'd like to try to keep it certainly to 35. If you can do it, you know, we'll say 30, do the best you can, and we'll cross that bridge when we get there.
I will not have a clock going, so if anyone wants to tell me I'm close, I will work within your parameters. That's absolutely as best I can.
Okay.
Thank you. So my name is Lance Ingalls. I am an attorney with Eisenogel, Seaver & Pogue, and I have been involved in local government and land use for the better part of 30 years. I have been a county attorney in the metro area, and I have handled many a land use hearing. Why are we here? Simple fairness. We do not believe that the process and hearing that went to the P&Z was fair. And we're going to get into those specifics, but I wanted to start with the big picture of why we're here. We want to correct significant factual and procedural errors that occurred at that hearing so that not just the developers, but also the residents and neighbors can get a fair opportunity to be heard. And finally, we want to receive a hearing that considers the whole and true story and history of the neighborhood, not solely what's been presented so far. What this appeal is not about, it's not about access. I'll show you that again in a minute. I'll show you the access easement. The access easement actually gives the landowners the right, without any input from the town whatsoever, to take access from the front or rear of the property. It simply defines where it would be taken in the event they choose one or the other. The town does not need to act on that. The town already has. This is a hearing that was about the setback, and the setback and the access easement were not the same thing. Not to deny development of property. None of my clients want to deny development, and they instead want to honor long ago agreed upon uses of the property. So they support full development of the property, but there has been a restriction on the property for almost 27 years now, and they are asking that that receive a full consideration of what it really in fact is. These issues may be confusing to you if you're listening to me and saying, that Mr. Ingalls doesn't have a clue what he's talking about, because I've read the staff report. Yeah, you probably are a little confused if you've only read the staff report. What I'm going to tell you, I'm going to have to go into a little more detail to explain. This is your standard, and I point this out at the front end so that you can understand what I believe your regulations say. You received a brief from the owners saying that essentially your standards are the same as what's called a Rule 106 appeal. Rule 106 is Rule 106A4 of the Colorado Rules of Civil Procedure. It is how an individual could challenge a land use in the district court if they wanted to go that far. The green language that you see there is absolutely verbatim for what Rule 106 says. However, all of the yellow language is in addition to what Rule 106 says, excuse me, and you have more authority because your regulations give you more authority than Rule 106 would give a court. In particular, I want to bring your attention to the last part of this that's highlighted. Acted without proper evidence or a sufficient factual basis. We're going to talk at some length about why we believe the record was insufficient and why the facts were either misstated or mischaracterized in a way that resulted in an unfair hearing. And I believe your rules explicitly give you the authority to consider that. And also failed to act in accordance with the provisions of this title. That essentially means your regs. If you believe that the process failed to comply with your regs, you have the authority to address that. I'm going to skip that at the bottom in honor of time. Let's start with definitions. At no point in time did the P&Z, nor were you presented during the staff presentation, the definitions of the key terms that we're talking about here. There's two key terms and they do not mean the same thing. And this is taken directly from your land use code and from your regulation. I have given you the exact site. I actually tried to cut and paste this from your code. So if there's a typo, I assume I added it. It might be in your code, but anyway, these are your definitions. An easement is an interest in real property granted or reserved by the property owner by deed or recorded plat. I'm not going to read the rest to you. You can read, but that is a specific thing. With an easement, you often have a description of what that easement is. Easement runs at all types. You can have a utility easement, an access easement, a site distance easement, a site view easement. There's all kinds of easement, water lines, sewer lines, different stuff, different reasons. those do get described. An easement that just says easement is hard to work with. You don't know what that is. Easements get described. Also, they have to be described as far as location. Where is the easement? You can survive a legal challenge that there's an easement as long as there's enough clarity where it goes that the property owners, the benefited and the burdened, know where that is. But you do need a description of where that is. That's going to matter here in a minute. A setback is a very different beast. A setback is defined as a distance from the property line. And it's a no-build zone. That's what it is. Again, your definition, your words, I won't read to you, but these are different things. They have different purposes. And it's my client's position that these terms were conflated or combined as if they were a single thing, where in fact they were not. This is verbiage directly from a town staff report that was in advance of this meeting, and certain provisions are highlighted. I'll read those real quick because I think it matters. Apart from the letter with the brief comment from the town as the property owner, no specific motion for approval from December 11th meeting by the Planning and Zoning Commission, and no recorded documents since that meeting established that the rear setback was intended for any purpose other than potential access. According to the staff memo from this meeting, the following history was clarified. Previous P&Z action. On October 23rd, 1997, PNC had directed the applicant to explore combining 6 lots into 3 or provision of 5,000 square foot. This is a portion of historic documents. We agree that this is a portion of historic documents, but it leaves out other critical portions of the same document. Staff also started its presentation with this statement. This top of this page is the start of the presentation, and then started with this statement. The building setback line was designed on the plats for the purpose of providing an area for potential rear access to each of the lots. Now, remember, we have 2 terms. We have setback and we have easement. This really just starts to combine them. It doesn't use either term. It just says they're one and the same. And the setback was for access. We do not agree with that position. Was the P&Z confused? Here's the start of their conversation as they received the staff report. What are we here to talking about? Was that exhibit? Did that reference the easement line? Was that the easement line? A couple different commissioners asked. Again, down at the bottom of the first page there on the left, was that the easement? And again, on the middle of the second page, on the right, the easement, it's the easement line, right? The property line is not shown. And the staff confirmed that this is location of potential access. Right now, there is no distinction, and there has not been a distinction between a setback and an easement and your terminology in your regs. The hearing continued that way, and obviously it confused the P&Z right from the beginning. History of the lots at issue. This is kind of important, and I'm going to go into a little more history than Mr. Quarles did. These lots were owned entirely by the town. These lots were for a land swap to build the town park. Your town is lovely, by the way. I haven't been up here since I was a kid. I didn't have a appreciation back then for what I see now. Absolutely gorgeous. Nice work. I'm jealous that you all get to live here. I don't. These lots were reconfigured in October of 1997 by the town. The town owned the lots. The town wanted to swap the lots. The applicant was the town. The owner was the town. The presenter was the town. This was all the town. And that was important because the town had latitude to do what it wanted. It could agree to a setback or oppose a setback. It was the town that was pushing the applications and the town that ultimately agreed on the restrictions. So what were those restrictions? Well, let's start with, this is October 23rd, 1997. You have heard there was a hearing in October of 1997. In fact, there were 2. There was one on the 23rd, and then there was one 5 days later. It was continued for a specific purpose. And different things were done at different meetings. And so I'm going to briefly touch on that. The first part of this motion, which I've pulled out and highlighted for you on the right, was Commissioner Green moved. And the first part is, it was already cited by staff in relevant documents. The second part was dropped, though, from the presentation, and I don't know why. Also, the rear setback of all lots will be 15 feet, and the clump of cottonwood trees on lot 7 will be served in perpetuity. So from the very first hearing on October 23rd, 1997, there was a discussion of a setback, and you will see very clearly there was no mention of access or an easement in that setback. It was what a setback is, a 15-foot no build area from the rear of the lot. So we advance to, this is now October 28th, 1997. These were the findings from that hearing. Because they're all significant for different reasons, I am going to take a minute to read that. I apologize. Your eyes are probably better than mine anyway, but I'm going to try and do this quickly. So Commissioner Steele at the time moved to approve this. I'll skip the rest of that. Number 1, the easement lots will be combined to create one 5,000 square foot lot. So it started as 6 lots. It ended up being 5. Number 2, a 15-foot wide rear yard setback for each of the lots shall be established, period. Included in the 15-foot rear yard setback shall be a vehicular access easement, excepting the westernmost lot. So we now know that the easement is mentioned separately. It's included within the setback, but it's not the setback. These are separate things. Why do you do that? Because you have to define where an easement is. It can't just be anywhere. It has to be somewhere. And this one is within the setback. Paragraph 3, in consideration of the standardized rear yard setback, the front yard setback, which is 10 feet, I'll just share that with you, for the lots shall be a minimum of 10 feet. However, a 5-foot front yard setback may be requested of Hark for any lots taking exclusive access from the rear. So there was 2 easements here. There was a front yard and there was a rear yard. And there was specific discussion. If the access was from one location, we'll adjust at least the front yard easement or setback, excuse me. Now I'm doing it. So there was a setback in the rear, 15 feet. There's setback in the front, 10 feet. But they explicitly talked about and moved and found that if the adjustment was that the access was in fact chosen from the rear, then you could adjust the front yard setback. There was no similar discussion for adjustment of the rear yard setback. That remained 15 feet. I'll skip number 4. It's the grouping of cottonwood trees. That does come up again, but not for our purposes. Paragraph 5, the applicant shall execute a subdivision agreement. We don't need that either. The approval based on the information contained here is based on the following facts. Compliance with the standards, top of the next page. An additional condition is necessary to ensure, I'm not even gonna try, I can't read that. And the proposed subdivision is unique. This one does matter. I'm hoping you can read paragraph 3 better than I can, but the subdivision is unique. It starts to talk about this historical lot and why it matters. And so it's justification, it's support for what the town decided to do. Remember, the town decided to do this. They were the owner, they were the applicant. This was their application. Now in October, this was not recorded. And it wasn't recorded because immediately after the hearing, attention was brought to the town that, hey, you had a problem with your access easement. Your access easement said that everyone takes access from the rear if even one property owner says they're going to take access from the rear. So there will be an easement on the rear if one property owner decides they want to do that. And what that meant was, and what was highlighted right after the meeting was, if one property owner, say the westernmost lot, said, I want my access from the rear, then there was going to be an easement over the remaining 4 lots at the time. It later became 4 lots total, but there was going to be an easement over the remaining 4 lots. And that was not the intent. The intent was to give these landowners the permission to access from the rear or from the front. And so a new application was filed. It was filed on December 1st of 1997, exactly 33 days after the first approval. And it came with a supporting town memo as to why that application was moving forward. Now, subdivision amendment application was comprised of 2 documents. There was a replat of lot 5 through 10, and there was a memorandum from the town manager to the P&Z. I just said this dated December 1st, 1997. We'll actually pull up that whole memo here in a second. Project summary, this is from December 11th. Remember, this property was already approved. This subdivision and reconfiguration was already done on October 28th. So on December 11th, this was the issue. The applicant requests amendment to the 102897 approval of a small scale subdivision affecting the 15-foot wide vehicular access easement on the north boundary of the property. There's no mention of a setback, and back in 1997, town staff actually used that terminology correctly. They said setback when they meant setback, and they said easement when they meant easement. This is a depiction of something else you've already seen in your notes. You've seen that the easement extends to all the lots if access is from the rear, except for the westernmost lot. The hashed, I don't know what to call that, the hashed area at the top of the plat is the easement. And you can see the setback line underlying that easement. The setback line extends all the way to the west and all the way to the end of what is at the time lot 5. But the access easement stops when you get to lot 5 because that's what the language said. Here is a depiction. This was submitted in December 11th, 97 before the hearing. And you can see those are treated differently on the plat as a depiction for the P&Z at the time to understand those were separate issues. But also, as you already saw, that hearing was about the access easement. It was not about the setback. So this is the memo from the town manager in support of the application. You don't have to take my word for it. The first sentence says that. The town of Telluride hereby requests an amendment to the application described above to limit the application of the 15-foot wide vehicular access easement located on the rear of the property. This memo is part of the application in December of 1997. It's been kind of minimized and ignored that that's the fact by staff. They've talked about a memo. They've talked about a comment from the town manager. This was the land use application portion for December 11th, 1997. Now, if you skip down, again, this is because they were worried about a veto on the rear where all of the lots would be subjected to an easement, whether they wanted it or would use it or not. The second highlighted portion on the left there says the easement literally removes 15 feet of land from the rear. And that's a problem if they don't want to use it for that, which could be put to use as backyard open space by the lot owner and effectively limits the 100-foot. So rather than being forced to have an easement that you can't use, the town manager acknowledged that it would be better to use that for backyard open space than be forced to leave it at an easement that you don't want. Skipping to the next side of the page, the required 15-foot rear yard setback set by the commission is not objectionable and would appear to meet neighborhood concerns of views and proximities. Remember, this is the town's application as the owner. They were agreeable to the setback and they acknowledged this was for the town residents who had expressed concern. And then finally, in this memo, at least, to address this issue, the town seeks to make the easement, not the setback, the easement truly discretionary. The place of access was discretionary. You'll see that in more detail here in a second. Post approval, the amendment was approved. Access was the only issue in December of 97. The setback and its purpose remained unchanged. You'll see that in more detail in a second. Recorded in December 19th of 97. Recorded, that's when the easement was recorded. Also by the town of Telluride. That was the landowner at the time. That was the applicant at the time. That was everything at the time. After the plat was recorded, the access agreement was also recorded. And for most of these lots, for 3 of the 4 remaining lots, the 97 approval is still in effect. What happened in December of 97 is still what we're dealing with today. So again, this is from the December meeting in 97. The motion was limited to the removal of the vehicular access easement. And this language under it talks about HARC review. It talks about where the curb cuts would be, 10-foot curb cuts, by the way, for access off the front, not 15. Your access is generally less than 15 feet. This is the plat. Don't even try and read that. You'll probably hurt yourself. I know I would, but I wanted you to see this was recorded after December of 1997. But I did want to highlight this portion for you. The red is mine. The original was black, but this is what was recorded and remains in effect for lots 7, 8, and 9 today. Lots 5 and 6 were combined in 2015. We'll get to that in a minute. But you can see where it's circled, and I've made it bigger because I need that. I think I'm sadly older than everyone here. But 15-foot rear yard setback. That's all that 15-foot line said. That has been on the plat again for nearly 27 years. We're getting to that 27-year anniversary, and that is all that is on that plat today. This is the access easement that was actually recorded. It does 2 things, and while you can read it, and I've printed copies for you if you want to do that. On the left-hand side, it talks about the 2 options for access. Do you want option A, which is rear access? Do you want option B, which is front access? You have a choice. What triggers making that choice? That is the red box, on the right. The election of vehicular access by means of A or B above shall be made prior to the first submission of an application for residential development on any lot before the Historic and Architectural Review Commission. So the reason we are here started with a desire to develop the properties. Again, if all you've seen to this point is the staff report, that fact is probably lost on you. The development process did begin and it did result in the application that's currently in front of you now on appeal. And finally, paragraph 3 at the bottom, this access agreement and easement shall run with the property. This was the easement. There was no easement on the plat. There was no discussion of an easement on the plat. This was it. And it gave the 5, now 4 property owners discretion as to how to exercise that. The town didn't need to do anything with access. That was established by this easement back in 1997. You still don't need to do anything about that access. The landowners have agreed that access will be the front. They had every right to make that decision, but when they recorded the document, they overreached and also tried to get rid of the setback. So starting in 2015, we saw one application that I guess started to conflate the issues, although I don't think it did. I think it's been relied on for that though. Telluride was no longer the owner applicant. It had transferred these properties shortly after the December 97 hearing to private owners. It's been in private ownership ever since. And in 2015, one of the applicants that's in front of you today moved to combine lots 5 and 6 into a new lot 5A. They did that. This is a portion of the plat. I can't read the small portion on the big part on the right, so I did raise it up in the upper left-hand corner. At that time, the 15-foot rear yard setback also included the notation potential access, and it has the book and page of the access easement. This was prepared by the applicant at the time, which was the landowner at the time. This document was not prepared by the town. It doesn't say they're one and the same thing, but it does say the line is the same. I think that's fair because the access easement was defined as within the rear yard setback, but this did not make them the same document. Who was the applicant at that time? It was the Winters. The Winters are an applicant before you on this. They were an applicant. These are their signatures on that plat from 2015. They added that language. They combined the lots. They are still the owners of revised now lot 5A. And they, if there is confusion from 2015, they created it. 2024 applications, fast forward to now. This was because there was a desire to, okay. I'm reading my client's note telling me to slow down. I apologize. I'm trying to hurry and stay within 30 minutes. It's okay to throw something at me or raise your hand if I need to repeat something. I'm going to try and slow down a little. Am I at least being heard?
Yes, you're doing great.
We'll ask questions at the
Yeah.
end. of the-
Okay.
And I know,
Sorry, I've asked to be passed notes and I just finally took the time to read one. Led to an access decision. Front access was preferred. That was chosen. That's what got us started here. Prepared the easement vacation. That was actually part of the application, although for the most part, it didn't need to be, other than it added the setback issue to the attempted vacation. And staff so far has really cooperated with that effort to vacate the setback as if it was one and the same thing, and they've ignored the history that we've covered so far to get to that. Omissions from the record. There's a couple things here I'm going to touch on, and then I'm going to show you why they mattered. You are supposed to have in your packet for today a full land use application. You don't. You don't because the P&Z also did not receive the full land use application. I'm going to show you that your regs require that. I think that's a problem. I think a court would agree that's a problem. These are the your regulatory requirements of what an application must contain. I've only highlighted one of these because I've never seen a document that actually meets this criteria. I don't know if it exists or not. I did request and receive what I'm told is the application separate from the record. It should be in the record, but I did not receive a document that has a written description of the proposal from the applicant with an explanation in writing of how the proposed development complies with the review standards. I don't know if that document exists. I haven't been given it, but I can tell you it's not in the record anywhere that I have seen. I have asked for it. I was told there's a version of an application in the record. That document that I was referred to is actually a memo from the town, not from the applicant, and I don't believe it is an application. Here is part of what I received though. This is part of the application itself. This is the online form for the application, so it does exist. This is a supporting document that came with it. You can see the Winters are one of the applicants here today, the same as they were in 2015. The other applicant is San Miguel Properties LLC, a Tennessee limited liability company.
And I'm really sorry to interrupt right here, but I believe that we are bound by your notice of appeal and issues raised therein, and this issue of omissions in the record and the completeness or sufficiency of the application is raised nowhere in the notice of appeal. And so I would ask that that not be considered by the council.
Ally, can you clarify that for us, please?
Yes, so Attorney Bryan is correct. The matters raised in the notice of appeal are the only matters to be considered. If this was not in that, and I believe it was not for an incomplete application, what the appellant is calling an incomplete application, that should be disregarded.
Okay.
Well, can I make a record on that? I didn't get an opportunity to respond. I was told by the town attorney on Thursday of last week that I could submit this with the record, but the town would not. And I could submit it with the record because of my reading that it is required. I'm going to show you in a minute from your regs that it is in fact required. But one of the things we're appealing is that there were omissions and errors in the presentation to the town. That was in the notice, and that made the hearing unfair. It made it insufficient, which is the term that you are allowed to consider today. So if you can't consider what information that was missing that made it insufficient, that makes your regulations somewhat meaningless on that point. I did not have the record when I proposed my notice of appeal. I didn't have access to it. It didn't exist yet. So I didn't know about this until after the deadline for preparing the record in the first place. I was told it wouldn't be added, but that I could add it. So I just need that in the record if we're going to exclude this information.
Okay.
So, Mr. Ingles, you can definitely suggest that the record is insufficient. And I think you are correct that one of the criteria for possibly remanding this is that there was insufficient evidence presented initially. However, this board cannot consider that evidence. They can consider that you are arguing that there was a lack of evidence, but they cannot actually consider the additional information itself.
I will skip forward through this. This was also part of the application I'm not allowed to talk about. Omissions from or misstatements from the record. The approval criteria are nowhere in the record. You did see when Mr. Quarles read the resolution, there was a reference to section 6-408, but that was never read into the record. It was never presented by staff. Section 6-408 was never discussed by the P&Z. It's not in the record. Consider the record. This is what I was telling you. The record shall consist of the development application. It does not, and I understand that staff's position remains and the town attorney's position remains that this will not be added to the record. I think that's absolutely required. This is for an appeal. That's what that language stands for. Also, the hearing procedure. This was in front of the P&Z, your hearing procedure. A hearing to consider the development application. They were considering an application they did not have. The applicant shall offer competent evidence and support. Again, I've never seen a complete application that would have even completely argued the approval criteria and why they met that. And it certainly wasn't considered by the P&Z. And the burden of proof was always on the applicant. I think staff really took that burden off of them and argued their case for them, and frankly did so inappropriately and beyond what the record supported. But the burden was always on the applicant. The applicant was never asked to meet that burden. The actual 1997 setback was never discussed as it existed. I've gone through records to show you that setback was a setback. That's what it was. It was conflated into the easement and said, look, if access isn't going to be taken there, the setback can also go away there. It was one and the same. That was not true. That information as presented to the P&Z was not true. It was not sufficient because it was misleading. The P&Z was denied and misled regarding that. The setback was never addressed as a standalone issue, but there's plenty in the historic records that show that's exactly what it was. They were treated interchangeably. That was inappropriate, and it did confuse the P&Z. I showed you that previously. Development plans on file were omitted. I'm not allowed to present them now either, but there were plans submitted with the application that was given to me as part of the application. They were not given to the P&Z, and the P&Z asked about them. They asked if there's plans. They asked if they could see them. They were told there are no plans, and those will be considered later when they're submitted. They had been submitted, but they weren't given to the P&Z. Relevant code provisions that were omitted and or ignored. One statement was made that the P&Z does not protect views, but your code does. I'll show you that in a second. And what is the regulatory basis for removing a code compliant setback? There was all kinds of discussion in the 97 approval in December of 97 about the reasons for a setback or the reasons for the approval, not specific to the setback, but it was a historic neighborhood. It had some unique aspects to it, and that setback was approved. That setback was now removed with no discussion of that history or historic nature of the lots and why it was approved in the first place. P&Z concerns, they had concerns about removing the setback, but they were minimized or passed over by staff, and they really never got to finish their conversation. This is your reg, and why I say that preservation of scenic views may matter. It's directly from the purposes of your reg, section 1-103, manage development in a manner that encourages the preservation of scenic values, historic structures, and unique scale of original Telluride. These factors were addressed in 1997. They were not addressed this time around. It's just, hey, let's follow the current rules. That's good enough for everybody. That ignores that the rules that were in place, the setback that was in place, had complied with the regulations, and this was never discussed why we would simply take away something that was previously done right. Significant errors in the process. New information was allowed after the public testimony. After the people that were in the room who wanted to speak were allowed to speak, other information was added, and there was no chance for citizens to rebut that information. There was a detailed discussion of notice. There was no notice at all of the purpose of the setback. And there's no recorded document that talks about the purpose of the setback. The setback is what it was. It was a no-build area, and there was perfect legal notice that there was a setback of 15 feet on the rear of these properties. That's indisputable. You've seen it. there was a 15-foot setback. Now it's a little bit of gamesmanship, and it was gamesmanship after the public had been allowed to speak. Well, there's no recorded document that tells us exactly the purpose of that setback.
3 minutes.
Okay. Mr. Mayor, shall I continue to hurry through my presentation, or should I jump to conclusion? I said I'd try and work within the 30 minutes, and I'm not sure what slide we're on.
You have 6 slides left.
Yeah.
Okay.
Yeah, you're hustling, so you can keep going. We appreciate it. And I want to be clear that, council, any member, if they think it's being hurried or, want us to slow down, we can do that. Personally, I think everything is clear and understandable because of the packet we received. With some of the confusion with the time frame delivered for the 30 minutes, I'm okay with letting you go a little over. And again, the other side will be able to have that same courtesy if they need it.
Thank you. So errors in the record, new information was allowed. This one gives me some pause. I have met your assistant town attorney. She seems very nice. I don't assume this was on purpose, but there was a discussion in the record where one of the P&Z members was talking about leaving the setback in place and only getting rid of the easement. And I'll show you that here in a second. But essentially, there was a discussion during their deliberations. So everyone had said what they had to say. The applicant had got their chance at rebuttal, and they were deliberating and trying to formulate their motion. And in the middle of a sentence, your P&Z member was interrupted by the town attorney with facts that kind of redirected her to a different place. She never even got to complete her thought. That is wholly inappropriate. The attorney's office is to help your P&Z make a record that is clear, a record that is legal. It's not to redirect their deliberations. And while I don't think that was necessarily intentional, I do think it was significant. And again, I'll show you that in a second. And finally, the P&Z brought their own history. You can see several P&Z members talking about it. I've given you some of those line items here, but if you've read the record, if you've read the 186 pages, you've also seen this yourself. They had a discussion of the history of the lots because the history of the lots mattered to them, and it really hadn't been fully vetted out for them. So they brought their own, and some of it was probably correct and some of it was probably incorrect. But again, the public had no opportunity to talk about that. This is the attorney representative for the applicant. I told you a minute ago that she brought in the notice issue and the lack of notice issue. I can tell you that this notice of a setback on the books for close to 27 years is absolutely defensible. A competent attorney can defend that setback if the town elects to leave it. The argument that the purpose of the setback hasn't been on record in an official document for 27 years, I think is a little misleading, but it's also irrelevant. So to the extent the brief talks about that as an issue, it's not really a legal issue that I would be concerned about. At the bottom of this, the yellow at the bottom, you'll see it's clear from staff's report and staff's presentation presented earlier too at the code, the applicants here are not asking for special treatment. They relied heavily on your staff because they didn't independently meet their burden. We've talked about that a little bit. So this is the summary. This was also done after the close of public testimony, or at least after those present who wished to speak were allowed to speak. One of those members of the public wanted to address comments by the P&Z when they were made later. She was not allowed to speak. She might be sitting to my left. I'm not sure. Finally, a couple things. P&Z was kind of given assurances that, hey, we're still starting with 15 feet here. There could be adjustments, but we're still starting with 15 feet. Here's one of those references. Here's another. This is the part where one of your P&Z commissioners was interrupted. Starting on line 1111 there, Commissioner Dye started talking about, and there's a significant typo in this, which I'm going to cover here in just a second, that I'll read just the highlighted part. So I'm going to start in the middle of the sentence. 10 feet of another 5 feet plus the 5 feet setback that is an unusual subdivision weighs heavy on me because I think there's been certain reliance. So if we could separate, certainly approve the removal of the access piece, but keep and I'm going to read past the yellow, but keep the 15-foot setback for building purposes seems, I think, the word here is unreasonable. The word on the tape is reasonable. Seems to be reasonable. And you can speculate what she's going to say next, but we'll never know because she was cut off with intervention from the town attorney, assistant town attorney, wanting to be clear that this process would go to Hark. And at the end, also, I think an incorrect statement and one that didn't belong in P and Z deliberations, that'll be considered, last 4 words, once plans are submitted. Plans were submitted. They weren't given to the P and Z even upon the P and Z's request to see them or to at least hear about them. They weren't submitted to you either. I did offer to submit them, but I've been told I cannot. There were plans, and those plans were significant to Ms. Dye. She was redirected. She wasn't going to go that route. This is also from the brief. We raised the issue that there may have been a conflict of interest. One of the P and Z members employs the representative for the applicants. This is directly from your regulations. If there's a close personal or close business relationship, it needs to be disclosed. I don't know the nature of how close that relationship is, but the brief confirmed that there's a business relationship and confirmed that the individual does in fact work for the company being run by in part the P and Z member. So there's no question there's a business relationship. The appellants in this case shouldn't be forced to guess what that relationship was. That's what disclosure is for. We're raising this. In the opening brief, it says, oh, don't worry about that. Only the representative is being paid, not the P and Z member. That's not a conflict. Well, it is according to your regs. There's a close business relationship. It wasn't disclosed. I believe there's a conflict of interest that's appealable. So what now? You can do several things, and we're asking you to look at this record, to look at this history and say, I don't think that was right. I don't think that was fair. I think the evidence was insufficient to fully address what was raised at the P and Z, and the P and Z was either confused or in one case wanted to go a different direction and was re-steered back to a different result. This process was not fair. There were some interventions, and probably with the best of intentions, I can assume that, but nonetheless interventions that derailed the process. You can overrule the P and Z directly and reinstate the setback. You can remand it to the P and Z with or without instructions. If you remand, and frankly, my clients have no objection to remanding if that's what you choose to do, but they would request that you direct your staff to give the full history of what this setback was, the fact that setbacks and easements are different, and had this setback stood alone, it would have had an impact different in kind from the standard modern day Hark process to cover the uniqueness of the historic property and its formation back in 1997, so that the P and Z can decide if I'm going to remove the setback, it's important that the setback be addressed as what it is. It was a standalone issue. So if you remand, and you have every right to do that, my client would not object to that. Please give instructions, because otherwise we could repeat all of this again. Finally, I think you have the authority to weigh in on the conflict of interest. You could decide that issue and reverse on that issue alone. That is something that, along with the missing pieces of information that are black and white in your code that are required, that makes for an easy 106 appeal. Missing issues are, and this is the green language I gave you early, that mirrors 106. It is abuse of discretion to approve something without standards. It is an abuse of discretion to do something in violation of your code. To not have elements that are required in your code is an abuse of discretion. Now, the most important point I can raise, and this is my last slide, is you are the chief administrative body of the town. If there were administrative errors, only this body can fix it. At this stage of the proceedings, and with that language that is not offered to a court, all the yellow language I highlighted for you, was there sufficient evidence for the decision that was made? All of that language is solely within your purview, and you are not bound by the record that did exist to determine that the evidence was sufficient or insufficient. You can say, look, there is information that was missing that I think, had it been added to the process, could have yielded a different result. In fairness, the P and Z might consider this with all the information that they were missing, and they might reach the same result. That at least would be fair. But as it exists right now, my clients did not get that essential fairness, that keyest component of due process, and they were entitled to it, because not only developers get due process, so do residents and neighbors. And in this case, that was lacking. You have the authority, and only you have the authority, to exercise some of that discretion in your code, and we're asking you to exercise it.
Great. Thank you very much. At this time, before we go to the applicant's presentation, while it is fresh in council's minds, if you have any questions for Mr. Ingalls, please bring them up now. Seeing no questions for Mr. Engels, we will move on to agenda item number 4, which is the applicant's presentation. You're on.
Thank you. My name is Andrea Bryan. I'm with the law firm Garfield and Hecht, and our law firm represents the owners of lots 5R, 7, 8, and 9. The applicants in the underlying application that cited on by P&Z. In this instance, I do want to point out that Mary Elizabeth Geiger from our law firm was the attorney who has been handling this matter for the applicants really since its inception. And she is trying to participate via Zoom. However, when this was scheduled, she wasn't given any opportunity to state whether or not she could be here or what her schedule was like. And she has been traveling and she wanted to be here, but could not because of those travel plans. And I believe she's actually traveling through Glenwood Canyon right now and actually cannot at all participate in this, but she did want to. But I, of course, have done my best to get up to speed on the history of this matter and this appeal, and will be presenting on behalf of the applicants today. I do want to reiterate, as I stated in my earlier objection, that the appellants shouldn't be permitted to be raising new arguments not contained in their notice of appeal today. And that includes their argument that there were omissions in the record. That was not raised anywhere in their appeal. So I would ask that this council not consider that argument. And in fact, legally, we do not believe that this council can. Same with their argument that the applicants in the underlying P&Z proceedings didn't meet their burden of proof with respect to the factors contained in the land use code for considering the minor subdivision amendment. Nowhere in their notice of appeal do they state that the evidence was insufficient to meet those applicable factors contained in the code. So this board likewise cannot consider, or this council likewise cannot consider those arguments for purposes of this appeal. And along those same lines, I think it's very important to reiterate that this is an appeal hearing. This is not a new application before the board. And I would like to reiterate the burden of proof, because the decision of the Planning and Zoning Commission shall be affirmed by town council when considering an appeal, unless it's determined that the reviewing body acted arbitrarily and capriciously, abused its discretion, exceeded its jurisdiction, acted without proper evidence or a sufficient factual basis, or otherwise failed to act in accordance with the provisions of this, and the burden of this shall be upon the appellant to demonstrate such grounds. So it is their burden of proof, and it is a very high burden of proof. And the reason that Rule 106 was cited throughout our brief is because Rule 106 does use very similar language, and that case law is very instructive on how a court would come down on whether or not that burden of proof is met for purposes of an appeal. So it's highly persuasive in the council's decision on this appeal. It is, of course, the applicant's position that there was no abuse of discretion and that the Planning and Zoning Commission's decision was based on really the only appropriate and proper evidence in the record and contained a sufficient factual basis. The Planning and Zoning decision was based on the factors in the land use code and was based on the competent evidence, and that evidence was that the purpose of the setbacks was to accommodate a potential access easement, which is no longer needed. And so neither is the setback. And saying that does not mean that we're conflating the issues. The fact that the 15-foot setback was necessary to accommodate an easement does not conflate the two issues, bottom line. And again, the town's code allows an applicant to amend a subdivision plat to remove the setback as depicted on the plat following the factors in the code. That application was submitted here. The factors were addressed in the application. Noticeably absent from any of the factors that the board is supposed to consider is whether or not the neighbors agree. And I do think it is very important to remind this council, as Planning and Zoning Commission was reminded below, that the setbacks imposed by the land use code will default. And if the Planning and Zoning Commission approval of this application is upheld. So the applicant here is not asking for special treatment. We're not asking for a variance. They're asking to be subject to the exact same rules applicable to all other property owners in the town. The same setbacks that are applicable to all other property owners in the town within this zoning district will now be applicable to these applicants. The appellants, on the other hand, we're asking Planning and Zoning and are now asking this council to recognize what is effectively a view plane easement or a view plane corridor in the complete absence of any recorded document granting such an encumbrance. Had Planning and Zoning done that and made a decision based on an alleged view plane easement, there's no question that that would have been a complete abuse of discretion and a court would not hesitate to overturn that decision. It's important to note that 1997 memo from the town manager was raised in the record during the Planning and Zoning Commission meeting, was highlighted by staff. And that note does say that the setback, the 15-foot setback, would appear to meet neighborhood concerns about views and proximities. What it doesn't state is which neighbors' views and proximities, what neighborhood views and proximities. They want this setback to protect views of neighbors, but then don't state which neighbors. Without a recorded document providing constructive notice to the owners that their neighbors or which neighbors have rights on their property, those rights just can't be inferred. But they wanted the Planning and Zoning Commission to infer those rights, and they now want you to infer those rights. And as I've said, that would be a clearly arbitrary and capricious decision. And then conversely, the record clearly provides evidence that the basis for the decision to include a 15-foot rear yard setback was to preserve space for vehicular access. I would like to highlight one of the statements made by Commissioner Brown during the Planning and Zoning Commission meeting, who said, having been on both sides of things like this before, I come down on the side of sticking to what has been recorded and not trying to get into the minds of people 15 to 20 years ago. No place in town does P&Z, to my knowledge, impose view corridors. That's done by HARC. Commissioner Miller believed that the application met all of the criteria listed in the code for minor subdivision requirements. And indeed, it was not Planning and Zoning's charge, nor did they have authority to impose what would effectively be a view plane easement and view plane corridor in the absence of any recorded document anywhere indicating that one existed. At the very beginning of appellant's presentation, they said that this is about honoring a long agreed upon uses, but they don't point to any agreement. The sole basis for their argument below and on appeal is one statement contained in a memorandum. But a memorandum, as appellant's attorney is a very well-versed attorney in land use matters, knows a memorandum cannot create an encumbrance on a piece of property, and it didn't do so here. There is a 15-foot setback. We've acknowledged a 15-foot setback, and the code allows the applicants and provides the procedure under which they can remove that 15-foot setback as depicted on the plat. And as I've said, the land use code provisions pertaining to setbacks will then default. There was no due process violation at the Planning and Zoning level. The neighbors submitted their comments in writing and were permitted to speak and raise their concerns. That's what due process requires. And again, appellant's attorney, who's had a long history in government, knows that that's all that due process requires. The owners were permitted to rebut the concerns raised by the neighbors, but due process doesn't require that the appellants then be allowed a surrebuttal, which could go on potentially endlessly. And notably, as with all their other arguments, the appellants haven't cited any law anywhere in their notice of appeal, actually, suggesting that they are required to be allowed a surrebuttal or rebut arguments made by the applicants or rebuttal arguments made by the applicants. Ms. Geiger's statements regarding notice, I think that is an issue that was really misrepresented in the notice of appeal. They suggest that that comment was made after evidence had closed and during deliberations. But if you actually look at the transcript, that is absolutely not the case. Those arguments were raised during the rebuttal portion of the applicant's presentation, which they are permitted to give and follows the procedure of every town council meeting that I've ever been a part of. After that rebuttal, evidence was closed and then the Planning and Zoning Commission started their deliberations. The conflict of interest issue really is just a non-issue. They really don't even address the code provisions at all in their notice of appeal. And they haven't identified even a shred of evidence that there is any actual conflict of interest. It is beyond speculative. And I think that's an argument that can be easily dispensed with. And in fact, I think all of the arguments here can be very easily dispensed with. The appellants have not shown that they have or will suffer any actual harm. Their argument that they have is based on pure speculation. There is no development application before them. They have not articulated any harm that will befall them if the regular land use code provisions regarding setbacks that pertain to every other landowner in this zone district will also apply to these landowners. The bottom line is that the appellants here haven't met their extremely high burden of showing that the Planning and Zoning Commission's decision should be reversed. We ask that this town council affirm the decision below. And I also ask that you, if you haven't had a chance already, to review the appellant's brief.
Great, thank you very much. Does anyone on council have any questions for Ms. Bryan?
I guess I have a question. I'm not sure if you're the person to answer it, but can we get a little more information about the conflict of interest piece because it's kind of been represented differently? Or is that something I should ask later on?
Well, it would be their burden to show that there was a conflict of interest, and they don't have any information that they've presented that there was an actual conflict of interest. It's not our burden to show that there is no conflict of interest.
And what we can do also is right now, we'll ask any questions for Ms. Bryan specifically. And then right after that, then we'll open up with all the testimony that was given, as well as Ron's presentation, if that's, created any questions within council to then ask either staff or either of the attorneys here today. So,
sorry, one question. Part of your argument, or I would say, in fact, part of the core of your argument is based on competent evidence that the setback is to accommodate the easement. Can you just reiterate some of that or help demonstrate that those two items are connected in the way in which you portray?
Yeah, I do think that if you go to the 2015 replat of Lot 5, it states 15-foot rear yard setback, potential access. That's really the only recorded document that indicates at all what the purpose of that 15-foot rear yard setback is. And again, I emphasize recorded document. But honestly, it really doesn't matter if it said, even if it didn't say 15-foot rear yard setback potential access in that plat, if it just said 15-foot rear yard setback, as long as the applicants went through the process of submitting a minor subdivision amendment, which they did, to remove that, then they're permitted to do that regardless of whether that was just left blank and didn't contain a purpose at all. Now, if that had said 15-foot rear yard setback, or if the 1997 rear yard replat had said 15-foot rear yard setback to preserve views and then identifying neighbors, we would be, I think, in a much different position here. But there's no plat note anywhere on any of the plats that states that the purpose is to protect views. And yet that's exactly what they're asking, what the appellants are asking. We're asking the Planning and Zoning Commission to do, and now asking the council to do. So they're asking to create essentially recorded language that just doesn't exist.
And then a follow-up question on that for legal or for staff. Is there a requirement when in a plat or replat, when there is a setback as part of that platting to designate a purpose or I'll just say to designate a purpose for that setback?
So typically, if it's just a land use code setback, something that's been set by the land use code, that would not be reflected in a plat. If it was something that varied from the land use code, so say a 15-foot setback for whatever the stated purpose might be, that might refer to a separate document, usually how easements do as well, because it'll just say easement, might be an access easement, but then it will cite to another recorded document that might set forth the parameters of that easement, who it benefits, what the purpose of it is for, who maintains the easement, so on and so forth. So when it comes to a setback, I think your question was, does a purpose have to be stated? It could be, not always. And I know that doesn't quite answer your question, but that is, if it does refer to a separate document, that's where you would go to expound upon the purpose.
Mhm.
If it doesn't, then we fall back on these other recorded documents that might reference a purpose.
Thank you.
I have a question. I think it's for staff or legal counsel. So
I'm going to just interrupt you 1 second because what I want to make sure we accomplish is just at this time is the questions for Miss Bryan. And if no one has questions specifically for her, then we can open up to questions to either council or staff. So I just want to make sure we're good as council to move forward with Ashley's question.
I don't have any questions from Ms. Bryan.
Great. Sorry, Ashley, I
No,
didn't
it's
mean to
fine.
interrupt.
I'm just curious about, so in the motion, I'm looking at the October 23rd, 1997, the regular meeting planning commission, the motion that's been being given by Commissioner Green. In the motion, which was voted and then approved, it says at the end, which was highlighted, it says also the rear setback of all lots will be 15 feet and the clump of cottonwood trees on current lot 7 will be preserved in perpetuity. How does that motion translate then to the new maps that have removed the easement for the
So-
access?
What, is this in the packet that Attorney Ingles
Yeah,
presented?
I don't know what pages because I pulled it out, but it's this section where it was highlighted. I'm just curious about if that was part of the motion at that time, how does that affect the then platted maps? And how would that be memorialized, I guess, if it was part of a motion?
But can I try to answer that, Ally?
Yeah, sure.
So the October meeting, that motion was made at the October meeting. The December meeting, a separate motion was made, which designated the plat that we're considering today. The October meeting, any motions that were made, that was previous to the formal motion at the December meeting. Is that clear? There was, in
What
other
year are you
words,
talking about, Ron?
97.
Oh, no, I know
Oh.
what you're talking about.
so there were two meetings, October 28, I believe, which was the original approval of the plat. And then they came back in December of 1997 and actually approved the plat as it exists today, with the exception of the replat for lots 5 and 6. So the motion that's formal and approved is the one that was in December of 1997, not October of 1997.
So there's no mention of that in the formal motion that was approved, and then that resulted in the change, the replat map that we see now. So that part that was originally put in was not transferred to this
That's correct.
December 11th motion. I just want to clarify where that change, because this seems
Yes.
to be the only formal thing that was ever presented. There's nothing about a, site corridor easement or anything like that. The motion as made here, but it sounds like then that was overridden by the motion made on December 11th, where this part was not included for any sort of maintaining that for perpetuity. Am I understanding that correctly?
Ron, do you want to answer that?
Yeah, so the second, I mean, the second meeting was the motion that was made to approve the plat as it currently exists. The October motion, again, is no longer applicable because that was not the plat. I mean, that was not the meeting where the plat was recorded or approved for recording.
So Ashley, just to kind of clarify, I think what Ron is stating, this October 23rd, 1997 meeting, so Green moved to continue. And then you'll also see here, directed applicant and staff to explore reconfiguration. So this last sentence is something that was desired to be incorporated, but it's not something that was actually approved. We take the approval language from when final approval occurred. That was not this meeting.
Okay, so this was something that was presented, but then not actually put into the final approval as it was approved by P and Z.
I have a question for clarification. Which October hearing are we talking about? The first one or the one 5 days later on the 28th? On the 23rd, there's one on the 28th.
I'm talking about the one on the 23rd. I'm reading from this piece from the 23rd.
So the 23rd was previous to the October 28th, where they actually approved it. And then they came back in December and approved separately.
I have a question that kind of builds on this because I think Ashley and I are sort of getting at the same thing, but I'm looking at the October 28th minutes that show Steele moving to approve. And we can get into the content of it later, but I'm wondering why this set of minutes was not in the P and Z meeting, but it is in our packet today. Because that seems like a key piece of information for P and Z to have. Recognizing, of course, that like it evolved over the meetings, what the approvals were, but when they're looking for intent and reasoning for certain setbacks, it seems pretty cut and dry to me what's going on in this October 28th meeting and the intention. So did P and Z see this October 28th minutes photocopy?
No, I don't believe so. Again, we try to make or include everything that we need or that we think is relevant. And I'm not disagreeing with your comments. It's simply that the recorded plat that's in place that was being acted on was from the December meeting. And that's why we included the final formal minutes of the December meeting.
And I'm hoping that maybe the town attorney can emphasize as well that you all are bound today by the record. And that note was not contained in the record. And the appellants had the opportunity to present whatever evidence they wanted planning and zoning to consider in making their decision. And they didn't present that evidence. So they don't have an opportunity to do that today. And so I would ask that you not consider that to the extent that it is not contained in the record.
Well, I
So-
don't think reasons that we would get to choose to reverse or remand or modify is that the planning and zoning commission acted without proper evidence or sufficient factual basis. So if they're missing key information,
So if I may, this is in the record. So this was submitted through public comment. This can be this is page 105 of 186 of the agenda. So this is included as part of the record. So Planning and Zoning Commission did see the minutes from the October 28th, 1997 meeting. It's my understanding that this was submitted as an attachment to a public comment letter from Irene, Lexi, Susan, and John Tedenham, the Weasels, and the McDonalds as well. So page 104 and 105 of the record. So this is something that P and Z did consider. It is something that you can also consider.
Mr. Mayor, can I ask for clarification? I had understood that the owners were done with their presentation. While I don't agree with all the discussion that's taking place, I'm waiting for my opportunity for rebuttal.
Yeah.
Now they're being allowed to speak again in coordination with the town attorney. When do I get to address any of this?
That's a great question. Thank you for bringing it up. What we'll do now is we're going to continue with the questions that council has for staff and each attorney. And then we're going to open it up to public comment, and then we'll give a chance for rebuttals for staff, applicant, and appellant rebuttals. So we will stick to the questions that we have and go from there. Are there any further questions of council?
I mean, if we're asking, or is it okay to ask questions to staff right now?
It's opened up questions for staff.
Okay.
That's right.
So I do have a question about the conflict of interest because it was kind of represented differently by the different parties. Can you just explain that? Because one person said that they were employing the architect, and then our packet said that they worked for someone who employed the architect. And to me, those are kind of different in what qualifies as a close business relationship. So what is the actual factual relationship?
So the factual relationship of the claimed conflict of interest is that Mr. Miller, who is a member of the Planning and Zoning Commission, he is an alternate, did participate in that hearing and in the discussion. He ultimately did not vote on the matter, though. He is employed by the Telluride Ski Resort, who also uses CCY architects in connection with other developments and projects they do at the ski resort. Mr. Miller is a planner for the ski resort, so he does work with CCY architects. However, he is not employed by CCY architects. He is he works with them through the resort. So his employer contracts with CCY on occasion.
Yeah, yeah. Okay.
Any further, before we open it up to public comment, are there any other questions for either attorney or staff from council?
I have a question for Ally. Is it required to submit plans for site usage to planning and zoning?
So I was going to address this at rebuttal, but because you have asked the question, it was brought up by Mr. Ingalls last week when I spoke with him on the phone that there was not a complete development application submitted to the Planning and Zoning Commission. So how that came about, when we have an application, staff receives an application from an applicant. That application includes a lot of information that is not in the purview of a reviewing body, might not be within the purview of HARC or of P&Z. Those elements of an application, if they're not required, will be excluded when they are presented to the reviewing body. So in this case, there was one document, it was an architectural site plan that was submitted by the applicant in connection with this application. However, architectural site plans are outside of the purview of the Planning and Zoning Commission, should not weigh on a decision that they render. Therefore, it was excluded from the packet. So what was submitted by the applicant and what was included in the packet before P&Z and therefore in the record for you was the applicant's narrative, the draft final plat, the draft vacation agreement, and those can all be found on PDF pages 12 through 19 of the published record. Additional documents that were submitted by the applicant but not presented to P&Z included items such as agency letters. All that means is that whoever is representing the applicant at the hearing has authority to do that. That would be superfluous to the packet. It's not needed. P&Z doesn't need to know that there was authority by this person to submit the application. The application cover page was included, proof of ownership, owner authorization, and then of course that architectural site plan. So again, just documents that we need to check to make sure that there is authority to submit an application, that the applicant actually does own the property or has authority to submit the application, but not something that P&Z needs to consider. So what was presented before P&Z were things that were relevant to their decision making.
Okay, and just to follow up, so in totality, site plans are never presented to planning and zoning on any.
So it depends on the application that they're considering, but for a setback, no, the site plans do not matter. That is something that was presented to HARC and will be presented to HARC in the future if an amendment is needed. So those architectural site plans are irrelevant to Planning and Zoning Commission.
Okay, and so, sorry, when they were told that there were no site plans by the applicant, whether or not that is actually truthful is irrelevant to planning and zoning.
Yes. And here I would also just note that there was no objection from the applicant, from anyone else, that those should be included at that time. There was no demand by a planning and zoning commission member that they see that before rendering a decision. They did not need to see it to render a decision.
But somebody did ask for them.
They did ask for them. I don't know if it would have been provided, if it's not necessary for them to be able to render a decision under the criteria in the code, which is what we will always steer them to, is considering that criteria.
Is that because when you're dealing with setbacks, you're dealing with the property as a whole, not a specific set of plans? So what you're doing is you're changing it for the property as it exists, not based on a specific project that is being proposed.
Yes, you're looking at the envelope. You're not looking at the design of the project.
Kind of like how Hark's not supposed to talk about what's inside, what's going in the building.
No, I understand. I think I just struggle with the closeness of building proximity without necessarily knowing, given the fact that there's not like an alley built into this, or into that site.
Make sure everyone's speaking into the mic, please.
Sorry, that's me.
Any other further questions before we move the process to public comments?
No question, Mayor, but may I request a brief 1-minute recess just to use the restroom? to
Sure.
notice anything? Thank you. Apologies. Thank you.
And I do have a question, and Councilperson Enright returns.
Okay. We'll take a brief 1-minute recess. For the record, Councilman Enright has re-entered the room and the brief recess is concluded. We will resume with questions of either attorney, questions from council to either attorney or staff.
I have a question for staff. Just asking, what is the precedent for changing setbacks or removing setbacks? Like, is this unusual?
I don't know if that question's necessarily relevant to rendering a decision on this
Okay.
one application. What I would say is that there is criteria in the code, and that's what should always be looked at when reviewing each individual application.
Okay.
Great. Any further
I have a
questions?
follow-up. One of the things that was stated in the planning and zoning meeting was specific to these sites not actually having an alley behind them, as most of the map does. Does that have any relevancy whatsoever? Or, I mean, is that seen as a special circumstance or? I guess-
It could. So I just advise, if it was important to them, then it could be something that influenced their decision. I'm not sure how else to answer that question. It could have been important to them. And if it was discussed in the record, you would see how it might have impacted that decision.
I have a question for the appellants. Can you point to anything in the information that you've given us that shows that there was any sort of formal action set specifically to preserve view corridors versus access? Because it seems like everything that I've seen now is, and through the process, that it's all for as access easement. And I'm curious if there's anything that you have that shows that there's anything formal for view corridors or anything similar.
Well, yes, I can answer your question, but to do that, I kind of have to rephrase, but I'll explain why. So the question is, what was the setback for? And you're asking specifically, was there anything recorded about view corridors? Because you've been told, I believe incorrectly, that it was actually for access, and the records clearly indicate that. All of that is misleading. There was a setback created on October 28th of 1997. That was the approval of this reconfigured subdivision. And that is where the setback came from, and it was a standalone setback. There was no reference whatsoever to the access easement at that time. It was just a setback, and a setback by your definitions is what it is. It is a 15-foot, in this case, setback where no construction can take place. And there absolutely was discussion 33 days later in a new application filed by the town as to why that setback existed. But that doesn't change the fact that it was a setback clearly established on October 28th of 1997. So fast forward to December 1st, when the memo and new application was filed, that new application and the motion approving that new application was limited to an access issue. It was not discussing setbacks. And so when staff said that no, December 11th modified October only to the extent of access, setback remained a separate issue. So the setback doesn't say it's for access anywhere in the official records. It is for access. It does say that the access easement can be within the setback, but that is not the same thing. And the record does establish from the town manager, a memo to the file supporting the December 11th application that was not objectionable. That met some of the neighbors' needs. That doesn't make it a setback for view corridors. It makes it a setback that was validly in place. So there is evidence in the record through that town memo that there were some reasons behind that setback, but there's no question the setback was created. It was created in October of 1997, October 28th to be exact, and it did not address access explicitly in the approval of the setback or views. It just landed on a 15-foot rear lot setback.
Okay, you didn't totally answer my question, but
What did I miss? Because I'll try.
I guess I understand the creation of a setback and what that means and what that's for. But I guess what I'm trying to say is that I want to see or hear from you in all this information. Where in any recorded or officially approved documents it says that that setback has to be preserved in perpetuity and can't be adjusted or changed per any of the regulations that we have set forth. You get what I'm saying? Like, what memorializes that setback that it needs to be memorialized permanently versus any other setbacks in places where they can be adjusted and changed by owners and with approval?
Yeah, thank you. So it is not our position that that setback could not be changed for any reason. That's not our position. Our position is that there was not a hearing on truly what the setback was. There is absolutely evidence that the setback had something to do with neighbors' concerns. And that is in your official records. It was easy to find. You just have to look at that application from October 28th of 1997. And again, the application for December 11th. So the setback exists. That doesn't mean the setback is in perpetuity and can never go away. But if it's going to go away, give a fair hearing. Again, not just to the developer who doesn't want it. And I understand that. They're entitled to make that case. But give a fair hearing to the neighbors and landowners who did want it. They didn't want it for views. They wanted it because it had been negotiated. They were aware of it. It actually impacts their properties. They wanted the setback to remain. And they never really got a hearing on that. They got a hearing on whether getting rid of the easement also should have necessarily gotten rid of the setback. That was never the issue in front of the P&Z, or at least it shouldn't have been.
Any further questions before we go to public comment? Okay, we will start with public comment. We will start with people in the room first. Is there anyone in the room for public comment?
And Mr. Mayor, just for purposes of the record and to preserve the record and the appeal rights, we do object to any public comment during an appeal hearing, as that would call for essentially consideration of evidence not contained in the record.
Ally, can you advise a little?
She is correct that if there is any information that is presented by any member of the public that is outside of the record, you should disregard that information. However, it is our standard practice to allow public comment at all hearings.
Okay, will you help advise?
Yes, yes, to the extent that there is additional information that has not already been presented today, just please do your best to disregard that information. If someone does go off topic too much and tries to present too far outside of what has been presented today, I will object and we might stop that public comment.
Okay, great. And then once you object, then you'll let us advise us on what to strike from our brains.
And Mr. Mayor, just for the record, we would object to that instruction. Your rules say that if the board acted without proper evidence or sufficient factual basis, that is means for you to overturn or remand this decision. If you can't present what was missing, you can't meet your criteria, making your criteria meaningless. So we don't think all potential additional evidence should be ignored. We think it's relevant to whether there was a sufficient factual basis.
Okay, point well taken. Thank you for that. We'll see how it goes. Is there anybody in the room for public comment? If you're in the room for public comment, this would be your only opportunity to speak. Once we go online for public comment, we're going to shut down public comment in the room, just to be clear.
I was gonna read a letter that I have copies if I'm allowed to pass them out to you guys. I don't know if
I will defer to legal counsel on that. And Tiffany as well.
If you are the appellant, so you need to present either through your attorney or during the appellant's time, not as public comment.
Well, this is a letter from a third party, not directly from my client. She's asking to read it into the record or hand it out or both. It's not from my client.
I think it could be handed out and read individually by the members as public comment if it's not being signed by you as the appellant.
Thank you.
And then Ally and Tiffany, would it be appropriate to allow counsel to time to read this memo?
Absolutely.
Okay, great. We'll give everyone a few minutes to read and then we'll recontinue. Everyone ready to continue? Okay, last call for public comment in the room.
Ceci's not here.
Oh, didn't even see her disappeared. Okay, back to public comment. Is there last call for anyone in the room with public comment? Seeing none, we will go online. Are there any hands raised online for public comment?
Right now, we may want to give instructions to raise hand if they want to provide comment and then give them a minute or so. But I'm seeing none right now.
Okay, if you're online, the same second chance that was provided for the people in the room, I will give to the people online. If you need to raise your hand so you can be heard, please do so now. We'll give you a minute or so.
One hand that went up, I'm going to bring up the time clock for 3 minutes. I'm going to unmute John Weisel.
Okay.
Good morning. This is John Weisel. Can you hear me okay?
Yes.
Yes.
Okay, very good. I will keep my comments very brief for you.
Can you state where you live, please?
Well, that was my next comment. I live at 830 East Pandora Avenue in the town of Telluride, and my last name for the record is spelled W-E-I-S as in Sam, E-L. I've been the owner of the home for 23 years and a resident of the town. And typically I follow pretty closely, what's going on with development and public notices and so forth. But never as actively engaged as this. I participated in the prior P&Z meetings. And I just want to make a couple of comments, and I won't belabor any points that our council Lance Ingalls made. My interest in this primarily are in the town, making sure we maintain the truly unique character of the town. I think everyone agrees with that. And secondly, to make sure that the development is not overbuilt and consistent with the standards and regulations and so forth in the town. That said, I have no opposition personally whatsoever to any development of properties. It's good for the town. It enriches the experience of living there. So I think it's great. The thing that I was most concerned about during the Planning and Zoning Commission process were a couple of points. I just wanted to highlight those for you. I'm not an attorney, so I can't debate town of Telluride policy, regulations, et cetera, and would not even attempt to try to do so. The first thing that really caught my attention was in the discussion, there was a conflation of the terms easement and setback, used interchangeably, used to mean one thing, and it created some concern on my part. Where the core issues really being understood and thoroughly discussed. The second point I would make is on the notion of the application that was provided. I was looking for a completed application. I did not.
Mr. Weisel, I think I need to interrupt you. Are you
But-
represented by Attorney Ingalls?
Yes, I am.
Okay, then your comments also need to be incorporated through Mr. Ingalls' representation or as part of his time for a presentation and cannot be separately presented as part of public comment.
Okay, would you like me to just cease then?
If you would, I'm sorry. Thank you.
Okay. Is there anybody else online for public comment?
So next we have Lexi Tuttenham, but I believe that she may
She's also
be
represented.
So then we have, I'm going to skip the public comment. So we have Steve Ferris,
Okay.
who I'm going to unmute.
And please keep in mind that the time limit is 3 minutes for public comment.
Hi, this is Steve Ferris. I just unmuted. I just wanted to note that I was the town planner in 1997, and when this was originally approved, and I wrote the memos, you'll see my name in a lot of those, and in the record, working with the planning board at that time. And it was looking over it, it was an interesting subdivision at that time. It's at the edge of town, and we were concerned that this part of town would take advantage of its unique character, but also reflect the grid throughout the town. And I only want to make it clear that there was definitely two things going on. There was the easement in the rear and the setback. There were two separate items, and the easement was a choice for the owners to decide whether they wanted to use or not, but the setback
sorry,
was
I'm going
desired
to
to be
object.
preserved.
This is going so far outside of the record before the board, and
Ally, can you advise?
Again, it's relevant to a decision, but not relevant to your decision. And any information that Mr. Ferris wants to present should have been presented before the Planning and Zoning Commission when it was rendering its decision, and really is not appropriate for this appeal.
Again, I would state that we believe this goes to whether the information was sufficient for the decision that was made. This issue was the issue that was glossed over by staff, and then Planning and Zoning Commission did not fully understand it. This is a key issue. This is information that was inadequate for the decision that was reached.
and that was not raised in their notice of appeal either. So it would not be appropriate for the board to consider the lack of that information before the P and Z.
Ally, can you confirm that it was not part of?
Mr. Ferris did not present public comment at that meeting. P and Z did not consider any comments, to my knowledge. And I think the record would also reflect that no former planner or attorney, no former staff member of the town came forward to say what intent might have been at the time in 1997. Had anyone made this comment and the Planning and Zoning Commission been able to consider it, it might have affected their decision. However, again, today you are reviewing the record on appeal, not outside information. However, if you think that the Planning and Zoning Commission might have lacked a complete picture, there are decisions available to you in that capacity.
And I think my point is that they didn't raise this lack of a complete picture and point to what the lack of the complete picture was in their notice of appeal. Their notice of appeal was limited specifically to what they say was misinformation, i.e. conflating the easement and setback issues and not relying on the viewplane issues, a lack of due process, and raising and Ms. Geiger's comments and not giving the appellants an opportunity to do a SIR rebuttal, and then this conflict of interest issue.
Hold on one second. I have a question before we get into the rebuttal part of it. We will have opportunities to rebuttal. I just want to get to the matter at hand. Because Mr. Ferris's comments were not presented at P and Z, we cannot take them into consideration today.
You cannot consider the substance of his comments. However, you can consider that there is someone who has something additional to say. And if you think that that might be relevant to P and Z's decision, perhaps your recommendation today is that they lacked, I think it was evidence, substantial evidence or information to make an informed decision.
Proper evidence or sufficient factual basis.
So I'm just gonna wait till deliberations.
Okay. It's a tough decision whether to let Mr. Ferris continue. I'm gonna choose not to let him continue because it was not part of P and Z, and I'm gonna leave it at that. We'll have rebuttals and debates later on about whatever you need to after.
What's the
No, I
point of
think-
taking
no,
public comment?
yeah,
Because all he's doing is repeating what Mr. Ingles said.
Well,
He's not giving new information.
The point is that we're not supposed to be taking that information and using it for our decision, but
We can
if we
still
ha-
take it.
But if we have public comment, to stop public comment, you're stopping the process that we've established as council to.
But what my concern for doing it is that once you hear something, you can't unhear it.
But
And
I don't think he introduced any new information. He repeated a similar argument that Mr. Ingles presented, which was that the conflation and the confusion at P and Z of what an easement and what a setback are, and that these were not necessarily linked. So I don't think that's new information.
I think, and to add to that, part of what I wish to try to determine was their proper opportunity for all parties to provide all information necessary for planning and zoning to make a determination. So whether or not we hear this testimony as new information or evidence to the fact whether or not they were given that opportunity, I think are distinct issues. She's giving me the look like I'm being unclear.
No,
Yeah.
go ahead. You're
Yeah.
fine.
Yeah, but
Don't look at my face.
okay,
Not trying to
and
make it
even though the commenter was interrupted by town's council on this issue, if there are council people that want to hear it, then I will change my mind and allow it.
I think we just can't choose who we hear from and who we don't hear from.
Right. It's
That's
just
not appropriate.
right, and it's just tough to figure out. And we'll just, Ally, can you advise us what we're supposed to hear and not hear, or?
I will object if there is information that appears to be outside of the record. Again, having public comment during an appeal hearing is a little, it's a little strange, but it is our process. We do allow it. However, I'm trying to get you to a point where you are only considering information that was presented on the record, with the addition of understanding that the appellant's argument is that there is information that is not in the record that he believes is relevant. However, as I believe Mr. Enright was saying earlier, one thing you need to consider is whether that opportunity existed. And if it existed and it was not taken advantage of by the applicants, that was their chance, not on appeal, but at the original Planning and Zoning Commission hearing. So your job today is to review the record that Planning and Zoning Commission had in front of it when it rendered its decision and determine whether they erred.
So I would like then, if that's the case, then I would like public comment to be able to speak in their entirety. And then if you have an item to object to it at the end, for the record, for council's knowledge, please do. Because that was confusing for me and maybe confusing for other council members to interrupt him and then discuss it to try to figure out what he could say and what he couldn't say. And so I would prefer to then move forward in that way. We've heard Tiffany, I don't know where we are on the clock for Mr. Ferris. I think it was probably about a minute.
There's 2 minutes left and I unmuted him again, but he hasn't accepted the unmute yet. So.
Okay. And Mr. Ferris, we did decide that you can't continue if you would like to continue.
I'd like to continue, but I'm ready to wrap up. I felt I was only speaking to the question of whether it was a setback or an easement, and that was part of the appeal. So thank you for letting me speak, and good luck in your decision.
Thank you.
Thank you. Is there anybody else online for public comment?
No.
Okay, seeing no more public comment. We were going to wrap up the public comment portion of this special meeting. That brings us to item number 7 in my notes of staff response or rebuttal following public comment. Is there any rebuttal from Ron or Ally?
I have nothing to add. Thank you.
I don't have a lot of rebuttal. I just, my job here as town attorney, assistant town attorney, is to make sure that you are following the criteria for this appeal. So with that in mind, I want to make it very clear that as the town, I am neutral and I'm not on the side of the appellant or the applicant in this case. I'm on the side of making sure the procedure gets followed correctly. And that the record is also set straight on what exists and what does not exist, what was considered and what was not considered. So as my rebuttal, it's not a rebuttal to either side of the applicant or the appellant. Rather, it's me trying to help you understand what it is you should and should not consider. And also to make sure that any statements that I heard that might be misleading or incorrect are set straight with respect to procedure. So I already referred to the incomplete argument of the development application. The development application that was presented to the Planning and Zoning Commission, which is the document that is relevant for their decision-making process, was included at the hearing and is a part of the record. It is not incomplete. Staff determined that there was a complete development application and therefore forwarded it on to the Planning and Zoning Commission for their consideration. With respect to the argument of there being a setback versus an easement, staff did understand after receiving legal arguments from the applicant that there was a lack of notice here with respect to setting forth a separate setback and separate easement. And because of that lack of notice, staff did determine that there are one and the same, and it is just that access easement / setback that could be removed by the town. Staff did not see this and still does not see this as two separate matters that have different processes for removing it. Instead, it is one setback, one access easement together of 15 feet that can follow this process for removal. There is no notice as far as staff is aware, as presented by the applicant, that there was any intent to encumber the property for a view setback. All recorded notices all speak about an access easement. So that is what staff rendered this decision based upon, was recorded documents. Was there notice of this encumbrance? When there was not notice of this encumbrance, the issue became quite clear to staff that the issue for decision was just for that 15-foot access easement, which was also referred to as a setback. Mr. Ingalls stated at one point the criteria was not presented to the Planning and Zoning Commission. The criteria is stated in the staff memo. This is on page 49 of your packet and is very clearly stated as criteria for decision. Now, that information was not copy and pasted into the staff memo. Instead, it just refers to the section which those members then need to go click on and review themselves. But the criteria for decision was very clearly stated in that memo for the Planning and Zoning Commission to consider. I believe those are all the points that I wanted to address on the town's behalf on rebuttal. So I would leave it at this point with the appellant.
Great, Ally, thank you. We will move on.
Sorry, Mayor, may I ask a follow-up question of Ally on one of the points she just made?
Sure.
Thank you. Can you, Ally, if you may, please highlight for me the record or where staff, the evidence supporting staff's conclusion that the setback and the easement are one and the same?
So at these Planning and Zoning Commission meetings, when the Planning and Zoning Commission is to render a decision, there's a lot of decisions, I think, as Mr. Ingalls has probably touched on, that do happen in the background by staff. What to consider as part of the development application, for instance. We're going to leave out those authorization forms because they're not relevant. Similarly, this decision that was reached by staff, it's a legal conclusion. So it's not something that was presented to the Planning and Zoning Commission as a legal conclusion at that rehearing. And if they had asked questions about it, we would have answered, but it was not an issue for them at the rehearing.
Okay, but I'm sorry, I don't believe my question was answered.
Okay.
What is the evidence that supports the conclusion that the access easement and the setback are one and the same?
So again, it goes off of,
Or they are intrinsically tied
Mhm.
and they cannot be separated.
So it goes off of what's recorded. So someone purchasing the property, what would they be aware of as existing? And if they read this document and they see this 15-foot setback and access easement, and then there's no other recorded documents that refer to the purpose of that setback being specifically for views, then anyone who's doing a title commitment work on this property isn't going to understand the purpose of that setback. However, it does refer to the easement agreement. And that is where staff was able to get the information relating to the setback and easement agreement and conclude that there can only be, even if the intent was there to set it as a view setback, that should have been made clear. But for purposes of being fair, it appears from the record, from the recorded documents, staff believes that this setback was only put in place with respect to the access easement. So they are one and the same.
So minutes from a P and Z meeting not considered recorded documents?
No, so that it's an official document, but it's not a recorded document in the property records.
I have a question about that, though. I mean, based on the maps that we're seeing here, does an easement exist still? Is there actually an easement that says who it is for the use of and the
No.
outline of it? It seems like that went away, that the easement no longer exists and the only thing that exists is a setback and potential access.
So the owners could do away with the easement. So it is the setback that
There was, there. can
I'll
I-
let Ron speak on this one.
So as we interpreted it, it was a setback for a potential access easement. The access never recorded, there's no access easement. It's a setback for a potential access easement.
But no easement actually exists
You're
currently.
correct.
That's what I.
It feels like something was lost in translation from this P and Z approval to the recorded plat.
Initially, I don't necessarily disagree, but I also want to make sure that I'm not fighting on the side of either the applicant or the appellant. I'm trying to help you render a decision, understanding that you also don't want to render a legal decision, that this is an appeal. I'm informing you of the legal decision that was reached that led to this staff memorandum on the rehearing and the conclusion that the setback could be removed by the Planning and Zoning Commission. And that it was an access easement. The purpose of the setback was for access and not for views, because recorded documents in the county clerk's office do not reference that the purpose of the setback was for views.
But they're not, but you mentioned earlier, that it's not required to list a reason for it. It could just be a setback period.
It could so typically when there is an easement, like I said, it refers to a separate recorded document. A setback in this case, it is operating a lot like an easement, and again, refers to a separate recorded document, which is that easement access agreement, not a view corridor agreement.
I also don't believe the appellant, excuse me, is making the claim that the setback is for the purpose of use. I don't believe that that's part of the argument. So I don't think it necessarily should be part of our consideration. The claim, as I understand it, is that there is a recorded 15-foot setback for which documentation has been provided, and that it is not within our current ability to determine what that purpose was at that time, simply whether or not it was recorded and valid and is or is not tied to the access easement.
But there is no access easement.
Well, and actually in the notice of, let me make sure I'm saying all the right words, the notice of appeal, they do reference the purpose of the setback as misinformation. So like, if we're gonna say that there was misinformation, I think this is the misinformation that is being pointed to, unless someone else has interpreted that differently.
And I would like to try to keep this to the
Page
questions, and so we
Sure.
can deliberate after we've had basically closing arguments from each attorney. So I'd like to try to keep this out of deliberations yet and more into clarification questions from the closing response rebuttal from staff. Are there any further questions of staff? Okay, closing the staff rebuttal, we're going to go to the applicant response rebuttal. If you have any following the public comment.
The applicant or the appellant?
Is applicant.
Okay. I just want to reiterate what staff mentioned, which was that the appellants had the opportunity at the underlying Planning and Zoning Commission to present whatever evidence they wanted the Planning and Zoning Commission to consider. It would be a totally different matter if they had said, I have some evidence that I want to present. And then Planning and Zoning said, sorry, we're not going to let you do that. No one was cut off. No one was told that they weren't allowed to present certain evidence. They could have submitted any of this public comment at the time of the Planning and Zoning Commission. So you cannot now use the fact that they're saying, oh, we want you to consider additional information now in retrospect as a basis to remand that, because they were given that opportunity and they were given the same opportunity to be heard as any other member of the public in any quasi judicial hearing. No one was ever cut off. No one was ever prevented from presenting their point of view. And so the process was entirely fair. There was no due process violation. And I also want to reiterate once again that we keep talking about it. I'm sorry if I'm pushing your last name, Councilmember Shanette, sorry, I apologize. Mentioned, oh, I think something was lost in translation here, and that somehow this issue of the views maybe should have made it on to the plat. Well, then it should have made it on to the plat, so that future landowners actually had notice. And if you're going to have an encumbrance on property, such that the neighbors would have a right to give their point of view or object, then it has to clearly identify whose property is encumbered and who's benefiting from the property. They keep saying, oh, the neighbor's views, the neighbor views. Which neighbors? That is identified absolutely nowhere. And that's why recorded documents are so important. And those recordings don't appear here. And then the code sets the criteria for the application that was submitted in this case to remove that 15-foot platted setback. And again, the land use code is going to dictate the setbacks in the future. The setbacks are not going to go away. There are going to be setbacks. But the land use code dictates the procedure here, and the applicants followed that procedure. Staff found that criteria to submit that application was met. The appellants at the underlying hearing never rebutted those criteria. It was all about the views. Planning and Zoning based its decision on those code criteria. And again, absent from those criteria are neighbor views or neighbor input, or whether the neighbors object. If they wanted an agreement to protect their views, they should have gotten an agreement, and they didn't. And that's the bottom line.
Thank you for your response rebuttal. We will then move to the appellant's response rebuttal, and you have 10 minutes.
Thank you, Mr. Mayor. I think the evidence is pretty clear that there was significant information that was kept in various forms from the P&Z. There was discussion of purposes of this setback, but there was no discussion of whether there was a setback or not. Really, there was. There has been a setback since October 28th of 1997. That setback has existed on the rear lot line, and it's been 15 feet. There was no discussion at that time about it being for access solely. In fact, the access issue wasn't fully resolved in October of 1997. That was the issue that was reapplied for 33 days later on December 1st, when the town manager put in a new land use application. That application was because the access issue was confusing. It would have potentially dictated access on the rear for people that didn't want it. The only issue that was addressed on December 11th, 1997 was the access issue. The setback had been fully approved on October 28th, 1997. There was no mention whatsoever at that time of it being for the purpose of access. The access easement was mentioned as that would be the location where that access easement could be exercised. But the purpose of the setback was not addressed as access at that time. It wasn't addressed as for views at that time. But there was evidence that both things were discussed and considered. Today, really, you're being asked to approve, well, clearly it meant access, but it didn't mean the other. The evidence on both is roughly equal. It's just only one of those was presented to the P&Z in a way that they could meaningfully consider it. So the burden of proof is on the appellants, and I believe we have met it. There was issue taken with me using the word omissions as opposed to insufficient information. I don't think those words are inconsistent, but if you'll accept my correction of the record, anywhere I said omissions, if you could say information was not submitted, I think that was my intent, and I don't think there's any reason to strike those comments. There was an assertion that it's not conflating the issues to treat the setback and easement as one and the same. I would argue that's exactly what it is. Those are two different things. I'm willing to guess you, like other governmental entities, do not require a setback everywhere you have an easement. I have seen more plats than most human beings, and I have never seen a setback and an easement be a concurrent thing that's used. It was here. It was here because staff's position remains today that Those are one and the same in this case. If that's true, that's very unique. I have not seen that before. You can have an easement, you can have a setback, they can even overlap, and you would address that if they do, and in this case, that's what happened. But you don't typically have both, it's just not necessary. In this case, there were both, and they served separate purposes. The burden has been shifted to the appellant, me, to prove whether there was or was not a conflict of interest. I think what I've proven is there's a business relationship between a P&Z member and the representative of the applicant. That usually gets resolved at disclosure. We know there was a business relationship. We just don't know how significant it is. And it's not my job to prove that there was or wasn't. The responsibility in the code is there was supposed to be disclosure, and there was not disclosure in this case. That individual did participate in the meeting, and I think it's fair to ask him to disclose that to determine in the future, should you choose to remand, whether he should participate in that hearing. I don't know the answer because this wasn't disclosed, it was discovered later. And the extent of that relationship remains unknown. But the fact of the relationship at least implies that your code applies. So I keep pointing to the screen as if that's still up there. So just ignore me pointing. It was at one point, and I understand why it's not now. Different things happened in October and December. The reconfiguration of these lots was approved on October 28th. The second hearing in October, and then the access issue was reconsidered in December. Those were not the same thing. They did not replace each other. The only thing addressed December 11th, 1997 was the access easement, and that resulted in a recorded document. Ms. Slayton just referred to that recorded document as the setback and easement agreement. The recorded document is actually titled the access agreement, and it does refer to it as an easement within that document. It did give the discretion to the property owners to exercise it or not exercise it. We're not asking that the P&Z impose anything. We are asking that the P&Z have a hearing fully informed of the various different reasons for this setback. And if after that fully informed hearing, they decide to wipe it out and go with modern rules for this property owner on a historic property, then I think my clients will live with that. But that's not the hearing they got. So what they got was a hearing where staff really carried the water for the applicant and argued that this was one and the same, making their decision much easier. And if they strayed away from that and said, hey, I think these might be different, they were steered back to these are one and the same, and that's the result that they got to. I don't think that hearing was fair, and I think the records that I've highlighted for you reflect that. In 2015, that's the first time the plat mentioned access and setback at the same time. Again, that was an application from the Winters. The Winters are an application today as well. So to the extent that caused any confusion, it was caused by the applicants, not anyone else. And that didn't change the nature of the approval in 1997 for 3 of the 4 lots that still exist. The notation didn't change for 3 of the 4 lots. A 15-foot rear lot setback was identified. It remains until this approval is resolved one way or another. That's still true today. A memo is not an encumbrance. I heard that comment. That's true, but a setback is. And a setback has been on this property for nearly 27 years. Why is it so worrisome that the P&Z consider the actual setback in all of its glory or all of its heinousness, if you prefer? It was what it was. There was language that discussed it. There was at least 2 purposes we know about, and there might have been others. There's a definition of setback that applies here that for whatever reason until today hasn't even been discussed. They're separate things. A setback and an easement are not the same thing. They weren't the same thing in this case, despite staff asserting that in this case, in fact, they are. There was an assertion made that we're asking for what should have been a SIR rebuttal. The way a land use process normally works is the applicant presents their application. The public is allowed to speak on that. And then in the applicant's rebuttal, as long as they stay with what was presented during the public comment, then there's no need for any additional public comment. In this case, we raised the issue that we think new issues were raised for the first time. The lack of notice of specificity of a setback, for example, something that's not required anywhere in any code. The public should be given an opportunity to address the new information. Otherwise, they had no opportunity to address that information. It was information that wasn't in the original presentation. It came up during rebuttal only. That should have been reopened for that purpose. So all things considered, all of this being addressed, we believe there's plenty to indicate that the hearing was not in fact fair, that there wasn't an opportunity to address all these issues, that the applicant was given a pass on their burden to prove that they should get this vacation in this case. Staff took that on themselves, and staff did that in an incomplete fashion. We believe the information was incomplete, and as a result, insufficient for the decision that was made. And we are asking for a remand with instructions to the P and Z and with instructions to the staff on how to present a more complete application. We think that due process would require it. We assume that as the chief administrative officials of the town, you care about misstatements, you care about things that were potentially misleading. You can see in some of the P and Z's comments that they were a little bit confused. Why not remand? Let them have a full hearing on this issue and get to whatever decision they might get to being fully informed. What is the harm in that? Right now, the harm is neighbors, not the developers, neighbors didn't get a fair hearing.
Great, thank you. So now I would encourage any further questions or discussion from council, staff, and the appellant and applicant. And we'll start with any council members that have any comments, questions, discussions that they'd like to bring forth.
Mayor, yes. So question for staff, Ally, hypothetical situation here. If there was an application from a property owner, and as part of that application, staff was completely negligent in their duty, and not saying that's the occurrence here, but just for the sake of hypothetical, an egregious lack of background information, did not provide relevant documents, completely deficient in their duty in all regards. Despite that, planning or zoning approves the application. Is it staff's assertion that it would be up to an appellant for neighboring property owners, whoever the appellant may be, to have attended that meeting, provided that documentation that staff was deficient in that time?
Yes, so keep in mind that the purpose of your standard review on the appeal is whether the lower board abused their discretion. There's several different ways you could overturn a decision here. So at a planning and zoning commission meeting, at any lower board or commission meeting, if there's a hearing and that board or commission is rendering a decision, your standard or what you are allowed to review on appeal is limited to that record only. This is not a second bite at the apple. This is not de novo. You are not considering new evidence here. You are only supposed to be considering what the Planning and Zoning Commission considered, because again, our standard is not de novo on appeal. So you are looking at what Planning and Zoning Commission looked at. At that last meeting was the opportunity for the public to come and comment, whether that might be neighbors, potential neighbors, any other member of the community that has something to say either for or against, or neither. They could just be commenting on the project itself without having a for or against. But at that hearing, at that initial hearing before a lower board or commission, is the opportunity to present that evidence. And for the most part, staff will not and cannot object to the entry of any evidence that they want to make. Planning and Zoning Commission will then render a decision based on whatever evidence was presented, both by staff, whether it was deficient or not, by an applicant who can always supplement what staff presented, and by any member of the public who, again, can always supplement if they found that staff was inadequately representing a project.
But just to make for 100% clarity, you are saying that we, as the appellant body, would not be allowed to consider the negligence of staff in this hypothetical. If there was a complete dereliction of duty and that was not caught by a potentially interested party, that we would not be allowed to consider or weigh in upon that dereliction of duty should it later be presented because it was not a part of the presentation or the packet at that lower board hearing.
So I'm trying to balance this a little bit because I don't want you to consider information that was not part of the record. However, and I believe it is Attorney Ingalls who brought it up, our standards are a little different and our appeal standards in the sense that you can overturn a decision of a lower board and commission if they acted arbitrarily and capriciously, abused their discretion, exceeded their jurisdiction, acted without proper evidence or sufficient factual basis. So while no new information is supposed to be presented at this appeal hearing, if based on the additional information, without knowing quite the substance of all of it, but if you are hearing additional information here that you think should have been considered by the Planning and Zoning Commission that was intentionally left out by staff, if you do think there was a dereliction of duty here, then you probably could remand based on that standard, acted without proper evidence or sufficient factual basis. However, if you think that the Planning and Zoning Commission did have enough information to render a decision, enough information to render a decision, they did render a decision, then the code would say that you would need to uphold that decision, but I leave that for your deliberations.
Thank you.
Is that clear to everyone on council? Okay, great. Any further questions for either attorney or staff? I'll give everyone a few more seconds to think about it. Kind of the last opportunity before we move into closing the public hearing and hold our own deliberations. So I'll give us another few seconds if we want any other further questions.
Ally, did P and Z get this town Telluride memorandum when they did their hearing? One that we got in our packet from,
So I believe
I
Let me go.
I believe on page 20 of the planning and zoning, I believe that's the,
I think she's talking about this one.
that's the same, is it not?
It looks different. But it just might be the.
Oh, it is different. This is the planning and, yeah.
I just didn't hear the question. Could I, maybe I can help look.
oh, the memorandum of
And is the question directed to Ron, Ally, or somebody
to
else?
Ally, I asked it to Ally.
Okay.
The December 1st, 1997 memorandum.
Letter from the town manager.
the letter from the town manager was included. Yes.
This one.
Mhm. Yes, that one was included.
What about the
Yes.
letter
It's here.
from Eleni to P and Z March 21st?
No, so that was not included in the rehearing. You'll notice that the date of that letter predates even the submission of the application. Staff does not go out and look for all relevant materials and all relevant comments that would have ever come in. If someone, again, going back to creating the record, any of the information that is presented today, any of it, could have been considered by the Planning and Zoning Commission. But it is up to staff, applicant, appellants, public, anyone at that original hearing to bring in that information.
I think this is the letter that the one from Eleni that I'm the most confused about, because we had the application for this in January, continued to February, then this letter came in and then it was brought back up in June. So when did P and Z just receive this in their email?
So do the appellants or the applicants, do either one of you have any objection to me stating a procedural history on how we ended up here at this appeal? Just from a standpoint of original submission, hearing, rehearing.
As long as it's complete, no objection.
Okay. Attorney Brian, any?
Well, I mean, I object to consideration of this letter in general. I mean, this wasn't provided in connection with this hearing. It wasn't provided to me before today.
But I feel like it should have been by our. staff.
So I'll explain where this letter came from and how it was excluded from the rehearing. So an original application was submitted and was considered before the Planning and Zoning Commission for this item. I don't know when that was originally submitted. Ron could tell you, but there was a meeting that occurred, I believe, at the end of 2023 before the Planning and Zoning Commission. At that meeting, and it was this exact same application, but at that meeting, the Planning and Zoning Commission did not reach a decision. They did not approve the application. They did not deny it. They did not continue it. There was no decision that was reached. We then received an appeal from the applicant to town council. However, it was decided in discussing the matter with applicant at that time that because no decision had been reached by the Planning and Zoning Commission, the matter was not ripe for an appeal. However, they could resubmit their application for consideration before the Planning and Zoning Commission for an actual decision, which is what happened. They then resubmitted their application. That's why you received a notice of appeal a few months ago that never happened. That appeal did not happen. Instead, it went back to the Planning and Zoning Commission so that they could render a decision, which again could be approve, deny, or continue. The rehearing, which is what you are hearing today as the appeal, at that rehearing, the Planning and Zoning Commission approved the application. That is the decision that is being appealed today. Now, after the notice of appeal was filed, this letter was submitted by the prior P&Z chair for the appeal that never happened. So if this letter had been resubmitted by the prior P&Z chair for the rehearing, it would have been included in the packet. However, that is not the case, so it was not included.
Jesse, any more
No.
questions from that question? Any other further comments or discussion before we close the public hearing? Seeing none, I'm choosing to close the public hearing and then move towards town council deliberations and we'll see if we render a directed decision. We've heard a lot of testimony today from both attorneys as well as staff input. Does anyone like to start with questions, comments, anything for deliberation?
Could we have a 1-minute recess so I can go to the bathroom? I'm sorry.
Yeah.
Held it as long as I could.
I'm gonna get mine.
There's a restroom upstairs. Go upstairs.
Yeah, okay.
Okay, Ashley and Eleanor are now back in the room. We've restarted the recording. So we will resume from our brief intermission, I guess.
Mr. Mayor, this is not, I'm not making argument. I just need to preserve one more objection for the record, which is the inclusion of this packet, which I was never given until today. I don't know if this wasn't included as part of the packet for today's decision or appeal. Both sides were given an opportunity to make submissions. And if there is an appeal of this decision, I think it's important to preserve that because to the extent, again, that there's new information contained in here that wasn't in the notice of appeal, that wasn't in the packet. It's just, I don't know where all this came from. If council got it before today or not, but I don't think that that's appropriate. And again, that's to preserve an objection for the record.
We'll let Tiffany respond to that.
This is Clerk Kavanaugh. I'm just going to clarify that packet is just a copy of the exact slides that Mr. Engel presented. It's just in hard copy. The clerk's office printed the exact presentation that town council received today in hard copy and distributed it so that they could look at it more closely while he presented.
Thank you.
And I do offer my PowerPoint for the record today. It was a summary of the proceedings and why we're here. So I don't think there's anything inappropriate about that being included.
Okay, thank you. Thanks for clarification. Okay, and back to closing the public hearing and holding the town council deliberations. I want to make sure everyone knows that it's important to recognize that since we're closing the public hearing part of it, that there are no additional comments at all that can be received from town council, from the applicant, appellant, opponents, or any member of the public. But the town council can discuss in its deliberations with the town attorney. So we are officially closed on the public hearing and off to deliberations. Is there anyone from council who would like to start, have questions, comments, thoughts, what have you?
I would be in favor of remanding this back to planning and zoning. I think that without any ill intent, this process and the packets and everything were lacking information from staff, and was the P and Z meeting after reading the transcript was definitely sloppy and confusing, and it's sort of, I would just like them to get a chance to do over. I know we're not supposed to be judging based off of what we want the outcome to be necessarily, and what we are really just evaluating how the protocol of that meeting went. And I think that it could be better. And I think that, yeah, I'll leave it at that for now and see how everybody else feels.
Okay, thank you. Any other further comments?
Yeah, I'll go. I'm still a little on the fence of like how I want to proceed with this. And so I'm really curious to hear everyone else's opinions. But the thing that I find most troubling in the P&Z meeting itself, which is essentially what we're evaluating here, is the comments that Commissioner Green made after the closing of public comment. I feel like some historical context was introduced that maybe shouldn't have been introduced at that point in the meeting. And that's sort of my sticking point. I don't know that I agree that it was like that there was misinformation, but I do think bringing all of that historical context in during deliberations felt like the wrong place to have that. And that's where I feel like the appellants missed an opportunity to respond to something. I don't know if that's enough to send it back to P&Z. So that's where I'm curious what other people think. But to me, that's what really has the most validity in this appeal.
That there was a process issue.
Yeah, that potentially new information was presented after public comment, like during deliberations in the rebuttal section. But I think that maybe the historical context that was brought in. Let me see if I can tell you exactly which page it's on. Because that was, even in reading it last night, like that was what I kind of saw as like the part that sort of left me a little uncertain. I'm gonna give you a page to reference. Sorry, you guys, this is a long packet. Where'd it go? There's like a big chunk of text from Commissioner Green. Why can't I find it? Oh, wait. Oh, okay. So on page 154 of the packet.
Oh, no, can you reference a specific line number?
Yeah, it starts on 1020.
Do you mean when she was talking about we were trying to create an alley?
Yeah, and kind of that.
And create an alley.
Which that's where, like, I don't know if that's enough to be, you know, new evidence or new information. So I'm curious to see what you guys think as well.
I'm gonna probably push back a little and align a little bit with what Commissioner Brown said during this and say that, you know, when dealing with these types of determinations, it's important to look at the facts. And I agree that I think there could be a question of process, and that's maybe what we should discuss here about if Kathy introduced this information after public comment and all of that. Part of it is none of what Kathy presented here is reflected in any documents that are official reported documents. The idea that, you know, basically that this setback created a favorable situation for the neighbors in that it preserved their view corridors, but was ultimately for the intended use eventually of some sort of access, be it through the back or in the different 3-point accesses as presented. The fact that the required 15-foot rear setback is to the commission, set by the commission, is not questionable and would appear to meet neighborhoods' concerns about view and proximities. The fact that something was good for the goose is good for the gander, and that the neighbors got the benefit from that, but it was not memorialized in any way as a specific benefit to them that would require protection. You know, Kathy talking about the fact that there wasn't an alleyway there and that this was, the intention was to create an alleyway, that they had every opportunity when it was owned by the town to put in a right-of-way, public right-of-way via an alley in that setback, but they chose not to. So to me, it's like we have a lot of evidence of what they did. There's a lot of question about what they maybe wanted to do or what they intended to do. And I don't see how, even if that information is presented at P&Z, how it's totally relevant to the decision that they've made. So I haven't seen anything through this process that would show me that would change that if more information was given, that would override what was presented in a way that's meaningful. But I understand the question of process and the feeling that if the process wasn't abided by, there wasn't this public comment allowed for after the additional information was presented, I see how that could allow for a reset down. But I don't, again, I don't see how any of that information would be relevant to the determination as it was made.
I see where the line in the letter from the town manager, people keep pointing to that, but I feel like the October 28th condition that P&Z put in, number 2, a 15-foot wide rear yard setback for each of the lots shall be established, period. Included in that 15-foot rear yard setback should be a vehicular access easement accepting the westernmost lot. That's the point where the intent is very clearly established to me, that those are two separate things, and there's going to be a rear yard setback established. Boom, done. And it is totally within the property owner's rights to ask, because through our process, to ask for that setback to be, you know, removed. But P&Z is tasked with looking at each situation specifically with all the background information that they can get. And I don't feel like they shouldn't be getting this background information from a public comment. They should be getting it from our staff. And I feel like that's where we missed out on the full picture being presented to P and Z by our staff. The issue of the easement and the setback being separate, and the issue of, they talk about all the time, well, why was it created this way? Whether it's a PUD or whether it's a subdivision or even a zone district, what were the goals of the rules that were put in place at this time? And yes, there's gonna be separate items where there's a unique situation where a property owner can plead their case and explain why they think that that shouldn't apply to them. And that's where P and Z makes that judgment call on that specific situation. But I don't feel like P and Z was given all of the information for this. And in fact, they ruled differently earlier in the year, and all of that information wasn't put into this. So I just feel like it shouldn't be on the public to completely provide all of this background history. I feel like our staff should be doing that. And
Well, it shouldn't be on the public to provide it because it should be recorded in the documents. That's the whole point, is that you
this is a
shouldn't be
document.
relying.
This is a document. It's the minutes from a meeting that P and Z created, and we're the town of Telluride. We aren't the county. I've gone to look for recorded documents at the county that are totally wrong and missing and messed up. And the 90s were a crazy time, it seems, at the county. But we're the town of Telluride. We should be looking at the town of Telluride P and Z decisions that led us to this point.
Well,
It shouldn't be like all of that's irrelevant. We don't know what they wanted. All that matters is this document that another municipality or another government created that is completely missing the intentions of this body. In fact, that one of the P and Z members was the same member in 97 as now.
I guess, but the point is, it's like if the intentions were legitimate, then why wasn't it put into the final document? That's where I'm struggling, is it's like, yes, everyone's saying we meant to, but I'm like, then why didn't you do it?
But the fact is,
Have you seen any of the
Have you
documents
gone
from the
over there?
90s?
It's
Like
horrible.
nothing's in there.
That's the problem, is that
But
you,
as you can't punish current property owners then for the
I don't
misgivings
think
of
it's a
that.
punish. It's
There is
you
the
can make the
final
argument in the opposite direction. This was created with certain parameters, and I don't think they should just be chucked out because someone else owns the property.
and so is kind of part of the deliberation, and what we need to decide on is, are there people who feel that you have to, I don't know if draw the line's the right word, we're not attorneys sitting up here and judges and all that stuff, but have to do it now, is that, do you have to hang your hat on what's recorded, or try to figure out what the intent was when some people are no longer in Telluride, some people are in Telluride, and what is allowed and what is not allowed. And that's the challenge I face. I kind of, I struggle with, if a view corridor was really important at the time, why wasn't it stated specifically as part of this? And that's my big struggle. And I'm not trying to say, someone's right, someone's wrong. It's just, things were probably done a little sloppier back then than they should have been. And I think it's for us to decide, was all the information provided to P and Z to make the decision that they came up to? Or do we think we should send it back to them to make sure they've gotten all the information? Or do we, or potentially, you got to draw the line somewhere on what people can dig up from 1997 and till now to try to make a decision. And if it's recorded versus not recorded, opinion versus fact, and things of all that nature, it makes it a little tougher. And I'm not sure the answer either way.
I want to add one more thing and then I'll shut up. I do think
You don't have to shut up.
I also, it was stated many times that none of the members of the public were cut off, but if you read the transcripts, they were all ran out of time. So I think that they're asking for another crack at it with all of the information, and I think that that's fair. So now I'll be quiet, sorry.
I guess I don't personally think that any significant information was missing from, well, it's not even an omission. Was there misinformation? I don't necessarily think that there was misinformation presented to P and Z, and I think that's where I sort of struggle. That's where I kind of stay on the fence a little here. Because I agree with a lot of what Geneva's saying. And I also kind of, I don't think that, I don't necessarily agree with a lot of the assertions made in the notice of appeal. And I actually would say that a lot of the evidence, and including that, the minutes from the October 28th meeting, give evidence that the setback and vehicular access are connected. Like, I think there's more evidence that those are connected than that they're not. So that's where I don't think that I see evidence that would prove otherwise that wasn't already included in the original P and Z meeting.
Can you help me understand what that evidence is? What do you think?
Yeah, so on page 105 of the October 28th minutes, number 2, a 15-foot wide rear yard setback for each of the lots shall be established. Included in the 15-foot rear yard shall be a vehicular access easement accepting the Westermont lot. Like the fact that those
Totally
are.
disagree on interpretation.
Yeah, and the
I
fact that those are like stated together relates them to me. They're like in the same bullet point. So like, I feel like they're connected. Otherwise, I think they would have been 2 separate items.
I guess
The next line,
the
it
whole thing
says,
is,
in consideration of the standardized rear yard setback, the front yard setback for the lot shall be blah, blah, blah.
Yeah,
It's a
that
standardized rear yard setback.
but why does that, I guess my point is that there is no easement that exists. So there is no encumbrance on the property that another person has a right to. That's what an easement gives somebody, is that you don't own this property, but you have a specific right defined in the easement. So the easements that they're alluding to that don't exist would have been if these lots as originally platted would have had different owners, and the owner at this end would have need to drive on other people's property to access their property. That's what the easement would have granted them. That's why the most westerly one did not have an easement, because the idea would be that you would only access it. It would have probably been written like, if you're at lot 8, you can only cross over lot 9 and 10 to get to that property. The easement wasn't written, it didn't exist, so it doesn't really matter. But the setback existed regardless of whether there was an easement there or not. If there was an easement there, you could not just remove the setback, because the easement would have given rights to another property owner. The fact that that easement doesn't exist, to me now says the owners of the property have the right to then change that setback as prescribed in our rules. There is nothing in our rules that's saying that they.
Right to ask.
What?
They have a right to ask.
They have a right to ask, exactly. They have a right to ask and come in and say, P and Z, I want to change my setback and my rear to this thing, blah, blah, blah. Here's why I can do it. And I'm asking for your permission to do that. There's nothing encumbering on this property that would be a legal standing for that right not to exist.
I agree.
The argument, I guess, is that P and Z historically maybe made some allusions to wanting to do it to preserve neighbor rights, which I don't think is invalid. I think that there are people that are making discussions about, oh, and this is great because it preserves things for the neighbors. But none of that was then memorialized in any meaningful or legal manner that would be enforceable by anybody. So I agree that I think that there could be a question of process about what happened here, and that would be a good reason to maybe send it back. I'm not totally convinced that there's anything that would warrant a change in the decision necessarily. But if the process wasn't followed correctly, I think that then that's where we say, hey, this was an unfair process, regardless of whatever decision was made. And then that's where it could go back.
Go ahead, Dan.
To piggyback off of that, I think that there is a reasonable difference. It's reasonable to interpret that line from the October 28th, 1997 meeting about the setback in either Eleanor or Geneva's way. I think it's clear that that piece of information was not presented by staff to the Planning and Zoning Commission for it. And there's at least enough of a question to warrant a discussion and deliberation amongst that commission. And so if they weren't presented with that information to allow for that reasonable discussion based off of all the facts, then that leads me to the same conclusion of Geneva, that remanding this back to planning and zoning seems appropriate at this time.
Can you repeat
wanna-
what specific?
I'm sorry, I don't have it in.
It's page 105, the October 28th, 1997 minutes.
We're using different packets.
And is that the one that Ron said, because a new decision was made after it?
Correct. And these minutes were submitted as part of public comment. So P and Z did see them. They just weren't submitted by staff.
I just don't think they were framed with staff properly. I totally agree with the appellant's interpretation that the amendment that was made in December to it only had to do with the easement. It didn't change the setbacks.
And I
Which
think,
make them totally different and makes the October 28th stuff about the setbacks stand.
and I think to add on to that, even the motion itself is framed in such a way conflating them without allowing for an opportunity to discuss whether or not they were separate. It is framed, to quote from the resolution that was adopted by planning and zoning, application to remove a designated 15-foot rear vehicular setback from the subdivision. So it's calling the setback for the purposes of vehicular access, which is, again, as I raised earlier, part of the core question of the matter, whether or not those two things are one and the same or are separate.
Well, it says in the same memo, part 2 is a 15-foot rear yard setback for each of the lots shall be established. Included in the 15-foot rear yard shall be a vehicular access easement, excepting the westernmost lot.
No,
That-
actually, I was talking about the current, the most recent resolution passed at the end of June this year. Not the one in 1997.
Okay.
What of the record from the Planning and Zoning Commission included in our packet, page 145 of 145. That one, the very final page of the record.
I'm in agreement that we should remand it back to P and Z because looking through all these documents over and over and over, I can't help but notice this one thing that we've kind of skimmed over, which is like all of the owners of the subdivision must unanimously agree. I'm surprised that you didn't bring it up, but we can't interact anymore.
Hold on. No. The owners of the subdivision are a single owner.
No, it's
There-
two.
Two owners.
Sorry,
The
two.
Winters and the LLC.
So there are two owners. The neighbors don't own in the subdivision.
Oh, so it's just them.
Yeah,
Yeah.
and they're in agreement, which
And-
is
Okay.
how we got here.
I thought there were still 5 lots.
They are,
There's
and there's
There's
two
only
owners
two
and
owners.
5 lots,
4
and they
lots.
agree.
And then the
So
3
it's the
people.
Winters and the LLC that applied for the vacation of
And then
the,
who's the
these are the neighbors.
no, but who's the other guy that's on the,
For vacating that easement, it was within the owners that are on one side of the argument. It doesn't include the people who are on the
The
other
other
side. of
side.
that.
Which is not part of
For
the
the subdivision.
Yeah.
That's right.
okay, it's a lot. But I do think it should be remanded back to P and Z. I think there's some things missing, some stuff that staff didn't include or that P and Z didn't consider. It should be looked at again.
Is there any further discussion? I mean, I'll entertain a motion. We have suggested motions for reversing, modifying, or remanding, or affirming. Those are our,
I guess I just want to like bring up the question of like going back to what we're supposed to make our decision based off of. Do we feel like there was misinformation?
I would, if I were to craft a motion, I would cite the planning and zoning acted without proper evidence or a sufficient factual basis would be, I believe, the criteria that has been demonstrated to, that threshold has been
I think
passed.
that's where like, I don't necessarily agree that they had a lack of evidence.
I agree. I don't think they had a lack of
I
evidence.
think all the information was there, including the minutes from October 28th. Although they were submitted via public comment, that's not ideal, but I don't know if that's enough to say that they didn't have the evidence.
I hear that argument.
Like
And
what
this is-
evidence
and I-
wasn't?
And I think this is where that was the sort of the core of my hypothetical, where it seems a bit of an impossible standard where if there was an insufficiency in an application, for then the burden to be on a hypothetical appellant, somebody who there hasn't been a decision made already. So how do you know that you're going to appeal it if the decision hasn't already been made? And so if there was an insufficiency in the information presented by staff to planning and zoning, it seems an impossible standard to require a third party who may or may not have a harm done to them by a decision to present the information at that time in order to sway that commission.
I hear
Shouldn't
what
you
you're
show
s-
up to the meeting? If you know there's something that could affect you, you should show up to that meeting.
Also, I hear what you're saying, but what do you feel like wasn't present at the meeting?
The full record from October 28th, 1997,
So that was included in the,
only by the public.
But that's part of.
agreed,
Part of-
that's part of
part of
the
the record.
information that P and Z has on record. So my point of view is that information was part of the record. Should staff have submitted it? Probably. That's like a subjective thing. They felt like that wasn't the most relevant document and there were other documents that superseded that. But at the same time, I think P and Z saw that document and that's where I kind of push back a little bit that I don't think evidence was missing. I think that that's where, I kind of go back to the due process of was there information brought to the table after the close of public comment? That's where I can see something, but I don't agree that the evidence wasn't presented to P and Z and wasn't included.
I agree with Elena 100%.
So do I.
As I just,
Based off that.
I find it difficult.
Wait, no, I'm saying I don't agree with what Dan is
You don't
saying.
wanna
Saying then
remand.
Let's remand it back to P and Z based on Kathy introducing information too late in the game.
So, and that's where I feel like, what are we actually,
I'm-
where's
can be
the
on board with
error
that
here?
I would agree with that, and I would disagree with Dan that I think that the fact, it is unfortunate that staff didn't include it for whatever reason, but the fact that it was included via public comment means that the decision makers had access to it.
And with Kathy's comment, wasn't it said earlier? I mean, that's the hardest thing about this is that trying to figure out what intent was and kind of go back in circles of what's recorded versus what the intent was. I mean, that's the biggest challenge I have. And
And I think the other thing that sticks with me is there was a point where Councilperson Green, we're all way too familiar with everyone, was cut off by the chairperson. And I don't know what she was gonna say, and I wish I would have marked where it was, but there was at one point in the transcript that Commissioner Green went to say something and was cut off, and I wonder if that's what she was gonna say, but was cut off by the chairperson. And then seeing that later on in a place where it didn't really belong in the process, that's where that raised a little bit of a red flag for me.
I think there was a lot of interrupting going on, and I also didn't love the moment where Angela Dye or Commissioner Dye was stating that they could pass or they could address the two items separately, the easement versus the setback, and that was interrupted by our staff to redirect, and that was pointed out by the appellant today. So I think it's important that we cite the specific issues, but I think it falls under this umbrella of it wasn't a fair hearing and it was a little sloppy, and why not? What is the harm in sending it back again to make sure that it's conducted properly?
if you believe it was unfair.
Yeah, like I don't know if this will ultimately change the outcome of the
Maybe it
PNC decision, but in terms of just like addressing what was called out in the appeal, which I'm really trying to stick to that. That's the only thing that I think has legs to stand up, is the due process.
I mean, I'm happy to take further discussion on it but if we're ready for a motion, I'd entertain one.
I keep looking
Awfully
at you.
quiet
I'm
over
pretty
there.
quiet. I think candidly, I think that there were significant failures on the part of staff through this process. And I'm disappointed in that and frustrated that we're here at this point because I think we wouldn't be here had there been more structure around these conversations. That being said, our job is to appoint the commissioners to our lower boards and commissions that make these decisions and trust the decisions that they make. Everything I read previously, I was frustrated about. I mean, I'm frustrated about the fact that documents in the 90s look the way they do, but we see a lot of them and they all look that way. And hopefully in the future we've got enough recordings for people to really be able to get to the heart of what the decision making was all about in the first place. But I think that the concerns by the neighbors can and should be addressed by HARC through that process and through the process that we've set up for the development of the town. So I'm not opposed to doing this again and doing it right. I think everybody on this on this council has heard me say that over and over again, that we'll do it as long and as many times as possible to get it correct. But I struggle a little bit with remanding this back.
Can you?
Now that we've heard from,
What do you want me to
expand
expand
on why you struggle despite those deficiencies, as you yourself highlighted, what draws you then to the conclusion not to remand it back?
Because I trust knowing the commissioners that are on planning and zoning and the breadth of their experience. I trust them to have full knowledge to be able to make informed decisions and know where to look for that information. More so than me, for certain, when it comes to planning and zoning matters.
In that same light, though, is it, and from your own experience, I know from my experience, I put a lot of trust in our staff in particular, as we all do, I believe. And while I certainly also put weight with every public comment I receive, it is a higher threshold for me to accept as a fundamental fact how to phrase this precisely, because it's a difficult line to walk. When staff asserts something, it is much easier for me to take as hard and fast. We've all received and seen public comments that work very hard to portray a narrative precisely, and I engage with public comment with a higher degree of skepticism than I do with a staff memorandum or a staff factual finding. And so I believe it also reasonable to assume to a degree that in a circumstance like this, planning and zoning may not have given as much credence or time or consideration to public comment as opposed to the factual record presented by our staff.
But what was presented in public comment was the record. So there's no question about whether it's factual or not. It's not somebody's opinion. They're not saying I want this or I don't want this. They're saying, here's what was said at past meetings. I guess my point is that I understand that things in the past have been, maybe not as defined as we would like them to be, but the reality is that the law requires us to look at documents that are to be recognized as fact. And the fact that there might have been other intentions or wantings that were not presented in those is kind of beyond the pale of a commission's board or their scope to try and determine that. They have to look at what things say. Words matter. The way that this is how we run our world. So if we intend for something, we have to make sure that the document that we're utilizing fully explains that intention. Otherwise, it's kind of like it didn't happen.
And I want to try to clarify this as well, is that with Dan's comments, it's up to us in this meeting to decipher public comment versus attorneys versus staff in our own minds to make our decision. That's the same way it happens to P and Z. If they had it as public comment, if they had it as staff, it's up to them to determine what they think is right or wrong. They shouldn't assume just because staff says it, it's right, or if
Because the
public says it, it's wrong, or vice versa. You have to, each person, I think certainly I can't speak for P and Z, but I speak, for my council, and I value everyone's opinion, but also take every comment individually for what I think it is at that time, to not just say, oh, just because such and such is saying it, that I think that's more factual than somebody not, which is kind of what I interpreted from you, Dan, by saying you lead more credence to staff than you do the public comment. That's
If there is a conflict between what a public commenter is saying and what staff is telling me, yes, absolutely examine things on their factual basis. But the assertion was that those facts weren't fully presented in that meeting, except for by a public commenter. It is reasonable to believe or see a way in which, when there is a difference between how facts are being presented between staff and the public, that planning and zoning would put trust in the staff, who are experts in the field, and base their judgment on that. I don't think that is unreasonable to see how that string of it. That's all I'm trying to say.
But do you think that staff presented something that was not factual?
And I just wanted to clarify that's what it was. I think we can go down this rabbit hole, and it's just up to each individual person to determine what they feel is the factual statements of their staff, public comment, attorneys, whoever that may be.
And it's not, to answer your question, Ashley, no, not unfactual. There was nothing that staff said that was wrong or incorrect. It was incomplete. That's the difference, is there was an incomplete presentation by staff. They did not have that, the minutes from that October 28th, 1997 meeting. And that incompletion was key to a decision being made. And so if there was an incomplete record presented, that is crossing the threshold of acting without proper evidence or sufficient factual basis.
And I think that's been brought up multiple times, and for each of us to determine in our own minds by way of a vote and how we feel with those things, and based on do we think was a misinformation from staff that wasn't part of the packet, or do we think that because it was brought up and submitted as public comment that was appropriate? I think that's probably the crux of it. And I respect everyone's opinion on both sides of those, but we're tasked here today to try to determine if there was some conduct that determines a reversal, a modifying or remanding, or affirming the decision that's made.
So in the lack of due process argument that Ms. Geiger, the attorney for the applicant, introduced new information that didn't have the opportunity to be responded to, for those who agree that was not according to protocol, what of the recommended motion categories do you feel best fits that?
Wait, can I clarify? I actually don't think what Ms. Geiger said is new
sorry,
information. I think it's what Commissioner Green said was new information.
Okay.
Following the public
Either way.
closure of public
Yeah,
comment.
same thing. I just think for the record, I just want to be clear about that I feel like that's what, I don't want to speak for the whole council, but I
It's
brought that up.
probably the fourth
so.
one, because you could specifically state it if you want to make a motion with that.
Without proper evidence that was introduced with the opportunity to respond. I mean, I feel like it's more of a protocol thing than. An omission of evidence.
I think that's,
Wait, Geneva, what page are the motions on? I'm sorry.
It was in the.
They were handed out.
yeah,
Oh.
you got in that. I think that's the closest one.
I mean, I would almost say it's an abuse of discretion because it was the choice to introduce that after. But I don't want, but it seems, but I don't know.
I think it, I think the point of your, if you just decide to make whatever motion you want, I think the point will be clear, no matter whatever one you choose based
Well, then I
on the
wanna do
details.
No, yeah,
I
you
wanna-
do need to
I-
be
This is a
specific.
But it's
group
hard.
choice.
Right, yeah, no,
I'm
It-
not, I don't
right,
wanna.
but it's hard to pick because they're just examples that apply and you're trying to,
Well, these are all the criteria that we're allowed to make the decision on.
right.
And we can choose any that applies. We can choose one or we can choose multiple. But rather than just blindly making a motion, I'd love to see what everybody agrees or disagrees with so that we don't have to go through.
Yeah, I'm still, if we're gonna just talk about that and what motion,
Is it the land use
if we're
code,
going to,
the hearing procedure?
The.
Failed to act in accordance with the provision of this title specifically, the hearing procedure,
I mean,
would that be appropriate?
Sure.
don't know.
yeah, I don't know. I mean, it's really comes down to the opinions of, do you want to remand it back or not? I'm, you know, I have a similar feeling to me in that I trust my commissions and I'm not sure there's enough for me to go back to a remand. And I'm having trouble deciding that there is.
I agree with Teddy and me in that while I see that one instance of, you know, something being brought up, I don't know if it's enough to send it back to P and Z for me, but I think I could be swayed either way.
I think that remanding it back is still having faith in our commission. If we didn't have faith in our commission, we would just reverse it or modify it. But we're giving them another crack at it. What I was convinced by the appellant that this was an unfair hearing. And so that's why I'm feeling like, let's remand it back. Once the answer's made from that, the answer's made, but I think that they've raised valid points about issues with that process. And I think that anyone who read the transcript or listened to the transcript would have seen that that was incredibly confusing and people were interrupting each other and information was introduced at an inappropriate time. And that's a problem. And we get criticized as the town, I don't know about us specifically, the town gets criticized for not having consistent, fair processes from time to time. And I think we're given the opportunity to provide the opportunity for this specific hearing to be redone. And that's all.
If you feel it was unfair.
If you feel it was unfair, which I was convinced by the arguments that the appellant made. So.
I think we're at the point where we're just trying to figure out what the motion is so we can vote and trying to make sure that we don't put a council member in a position to make the wrong motion to best represent where it fits. Is that fair?
Yeah, I just want to I don't want to waste time on motions that people disagree with. I think that we're trying to build towards a consensus here. And it sounds like we have 4 people who wait, maybe it's just.
I'm on the fence.
Elena's on the fence. Jesse's would like to remand it. I would like to remand it. Dan would like to remand it. And
I would remand for process, just because I think that, like you said, that's the only argument that I see in anything presented that has any standing, I believe, and that if we are going to really stand behind decisions made by our commissions, we have to make sure that the process was upheld, even if rehearing it would have no change in the decision made. We have to stand behind the process. And I believe that there was evidence that that process was disrupted.
I agree with that. I feel extra things,
I mean,
but I also.
Sure, yeah.
I brought it up, so I clearly agree with it. I think, I think the applicants did everything correctly, and I think the appellants have validity in that part. I didn't really, that was the only thing that really stuck out to me as a potential reason to send it back. And I do agree that we have this process for a reason. We have this appeal process for a reason, and we have due process in our meetings for a reason. You know, I agree that I don't foresee this necessarily changing the outcome of the decision, but if we want to uphold our process, you know, to say that that is not enough of a reason to send it back to P and Z kind of says that our appeal process doesn't have any merit to it. And I do kind of want to uphold the fact that we have this process, we're here in this meeting, and if something wasn't done correctly, that matters.
And I think that's well stated. And basically, you either believe something was unfair or it wasn't. And that's where we're at. And everyone, I think, I'd like to think that unless there's any further questions, we're all in our own minds to have an idea what we want to do, just waiting on a motion.
Okay.
Well, I give it a shot. I move to direct the town attorney to draft a resolution to remand the June 27th, 2024 Planning and Zoning Commission approval for lots 5R, 7, 8, and 9, Block 20, East Telluride Addition, for a minor subdivision to remove designated 15-foot rear setback on the plat and optional rear access within the 15-foot rear setback pursuant to Land Use Code Section 6-402.c with the following finding: that the Planning and Zoning Commission failed to act in accordance with the provision of this title, specifically Telluride Land Use Code 5-206.c hearing procedure, when a member of the commission offered evidence without the opportunity for rebuttal during the deliberations process.
Second.
I'm okay with that motion. We have a motion from Geneva, a second from Dan. Geneva, how do you vote?
Geneva, yes.
Dan?
Dan, yes.
Elena, yes.
Jesse Ray, yes.
Me and no.
Ashley, yes.
Teddy, no. It's a strong, extraordinary majority of 5-2, so it will be remanded back to P and Z. No, we have one more item.
Oh, yeah, of course.
And so back to the agenda. We are now on to action item number 2. It is consideration of approval of an employment contract for the Telluride Town Manager. It says Kevin Geiger is to present, but he is ill. Does that mean, Ally, you're taking it on? Kevin joining remotely?
I believe Julia is going to be
Julia's going to
presenting.
present. Look at that.
Kevin's gonna try to tune in, but if he can't either speak or get on, I will take this. His absence.
Okay.
Okay, thank you. Okay, if Kevin is not online, I will try to help counsel through this items. This is the. Is he on? Yeah. Okay, great. And I will hold and allow him to lead.
All right.
Hi, council. It's not, sorry, hopefully you can hear me, and I'm under the weather today, but oh, there the video did start. Thanks. So for council's consideration in this afternoon session, we have prepared for you a draft of a town manager contract. And we're happy to announce that that contract is proposed to be with Ms. Zoe Donnell. That contract has been provided to you both in hard copy form, and I also have provided a Microsoft Word version of that to council late last evening. Wanted to draw a couple specific sections of that contract to your attention. One would be page 1, section 3, which is the term of the contractual agreement. It's an indefinite term, meaning that either party can terminate it at will or without reason at any point in time. It's called an indefinite or green contract on that issue. Compensation is provided in page 3, section 4, and you should take a look at those provisions to make sure that they're consistent with the understanding and some of our executive session discussions. It would also include a performance review after 6 months, and then a subsequent performance review 12 months after that. Section 4 also includes provisions relating to paid time off and retirement benefits. Finally, page 4 is a provision in section 7 relating to a housing allowance, which has been traditionally offered to town managers in the past for at least the last 15 to 20 years. In this instance, Ms. Donnell does not currently live in the town. That has been a provision in the past. We have allowed one town manager at one other point in time to have resided within a 15-minute response time. And that is the provision that we're including in that section 7 right now. I apologize. I know my voice sounds terrible and my head's more than a little foggy, but I'm happy to answer any questions if you have any. And thanks, Ally, for working so carefully with council on that prior matter, because I don't think I could have done it.
I just have one question. Under the performance evaluation, it talks about that after initial 6 months of employment, then annually thereafter from the date or as otherwise desired by the town council or requested by Donnell shall be eligible for a formal annual review, which may include a salary review and possible salary increases initially up to 4% after her initial 6-month review. So is that saying that at 6 months, then there is the possibility for a 4% increase then, or is that after that 6 months, at the next 6 months, starting as an annual review, then she would be eligible for a 4% increase?
Kevin, I can take this one to save your voice.
Thank you.
You're welcome. To answer your question, that would be at that 6-month time period. That's the same way currently staff merit increases are structured. So 6 months in is their first opportunity for that increase, and then annually thereafter from that date. So somebody hired January 1st, their first evaluation would be June 1st, and then that's their merit opportunity. And then June 1st of that following year would be the following. If that makes sense.
And just to further clarify, it is council's sole discretion beyond that initial review for whatever type of salary increase or compensation that council at that time wishes to offer.
Yes, it's always going to be up to council to direct the town manager and town attorney, both appointed position increases as you deem appropriate. The 4% was likely reflected because that was what was budgeted for this year for staff.
But not required.
But not
We
required.
can, that's at our discretion after 6 months and then annually after that.
Yes.
Any further questions from council for Kevin, Julia, or?
I have a minor question, Kevin. This is for you, and I apologize. I didn't see the standard phone allowance that we offer to staff in this contract. Is that necessary in this document as an addition, or can we just lean on that as internal policy?
I think we had received information from Ms. Donnell that she has her own phone and I believe wasn't seeking reimbursement for a phone plan, but if we want to add that, I think we could.
Yeah, that's what I have now, Kevin, just based off of our internal policies. If you have your own phone, the town reimburses you for that. So I just like to keep that.
And that's the $50 per month phone stipend if you use your own phone for town purposes. So I don't know if that needs to be written in the contract. If we're not providing a town phone, we're just giving that reimbursement via payroll.
I think we have had previous contracts reflect a reimbursement amount. So we should add that if you want.
So that's a reimbursement of $50 per month for voice and data.
Okay.
Any further questions or comments on this agreement within council or for Kevin or Julia? This is, I don't think there's a suggested motion, but since this is an action item, we will have to take action. There is there are people in the room. I don't know if there's any public comment from anybody. Tiffany, is there anybody online? Okay. Seeing no public comment on an action item.
Mayor, would you like a sample motion?
Would love a sample motion for one of my council people.
Kevin, I looked up the previous one, so I'm just going to read it off and let me know if you have changes. Move to approve the hiring of Zoe Denal as the Town of Telluride Town Manager under the provisions of the contract on record for the public meeting of August 19th, 2024.
So moved.
Wait, with a
$50
friendly
change.
amendment.
With an addition of phone and data reimbursement of $50 per month.
Okay, so
All right. Okay, we have a motion from Geneva, a second from me. Geneva, how do you vote?
Geneva, yes.
And yes.
Helena, yes.
Desiree, yes.
Ashley, yes.
And yes.
Betty, yes. Approved unanimously. Yay.
Very excited to take.
Speech, speech.
Yeah, I know. Get plenty of opportunities to public speak. We don't need that. Very excited, so thank you.
We move to adjourn?
I move to adjourn, sorry.